Good morning, Registrar, Commissioner, participants. I'm going to open today's proceedings with our land acknowledgement.
We've got legislation in place that is prohibiting.
I would like to open this hearing by acknowledging that the City of Hamilton is situated upon the traditional territories of the Erie, Neutral, Huron-Wendat, Haudenosaunee, and Mississaugas. This land is covered by the Dish with One Spoon Wampum Belt Covenant, which is an agreement between the Haudenosaunee and the Anishinaabeg to share and care for the resources around the Great Lakes. We further acknowledge that the land on which Hamilton sits is covered by the Between the Lakes Purchase 1792 between the Crown and the Mississaugas of the Credit First Nation. Many council appearing on this hearing today are in Toronto, which is on the traditional land of the Huron-Wendat, the Seneca, and most recently, the Mississaugas of the Credit River. Today, this meeting place is still home to many Indigenous people from across Turtle Island, and I am grateful to have the opportunity to work on this land. Commissioner, if I may, before we turn to the events of the day being the closing submissions of the participants, I have some housekeeping matters, and in particular, the introduction of additional documents into evidence.
Okay.
These documents include documents that were referenced in participants' closing submissions that are not yet in evidence, as well as affidavit evidence from 2 additional witnesses. The first 2 documents are HAM 64292 and HAM 64293. And both of these are practice guidelines from the Professional Engineers Ontario. That's the regulator for engineers in Ontario. And these practice guidelines are from 2017 and 2020. These documents were referred to in the submissions by the city and by Golder. At present, only the 2012 version of the PEO practice guidelines on this particular topic are in evidence, and Commission Council agrees that all 3 versions of the guidelines should be in evidence and before you. Registrar, I'd ask that you mark these exhibits as the next exhibits, which by my count are exhibits 239 and 240 respectively.
Noted, Council.
Thank you. The next document, which will be exhibit 241, is HAM 62336. And that is a city PowerPoint presentation titled Traffic Engineering Collision Countermeasures Review. This document was referred to in the city's submissions, the written closing submissions. It was raised during the examination of Stephen Cooper before you, Mr. Commissioner, but it wasn't marked at that time. Council for the city has requested that it be entered into evidence now. And of course, it's been circulated and part of the inquiry database. And as such, I'd ask that the registrar mark this exhibit again, HAM 62336 as exhibit 241.
Noted.
Thank you. The next exhibit is GOL 7504. And this is a signed version of Golder's PMTR Phase 3 report. It was referred to in Golder's closing submissions. A draft version of this report is already in evidence, although it is not identical to the current draft. But this signed version is not. Golder's counsel has requested that this document be entered into evidence, and Commission Counsel agrees that it should be before you. As such, Registrar, I'd ask that you mark this as the next exhibit. It's GOL 7504 as exhibit 242.
Noted, Council.
Thank you. Next, there are 6 email attachments, which Golder's counsel has requested be entered into evidence. These are GOL 6504, GOL 6505, GOL 6506, GOL 6507, GOL 6508, and GOL 6509. These are pictures and brochures sent by Trevor Moore of Miller Paving to Dr. Uzrowski on December 20, 2013. The email attaching these documents is already in evidence as GOL 6503. It's in the overview document. And we agree, just as a matter of completeness and at Golder's counsel's request, that this should be these 6 email attachment should be entered into evidence. Registrar, I'd ask that you mark these documents as exhibits 243 to 246, 248 respectively.
Noted, Council. Thank you.
Thank you. In addition to these documents, Commissioner, there are 2 affidavits that Commission Council has circulated to Participants Council, and both of them we ask be made exhibits. The first is the affidavit of Berdina McNeil, affirmed on March 15, 2023, which is document ID RHV 1045. And this affidavit relates to this affiant's evidence regarding matters relevant to this inquiry while she was in her role as a solicitor in the city's legal department. As I've said, it's been circulated to Participants Council, and thus I'd ask that it be made the next exhibit, Exhibit 249.
If there are no objections from any of the participants, then it should be marked as an exhibit.
Commissioner, I can confirm no participants have raised any objection to having this entered as an
Okay.
exhibit without examination.
Marked as an exhibit. Thank you.
Thank you. And the last document is a second of the 2 affidavits. It's the affidavit of Jeanette Smith, affirmed on February 22, 2023, and it's doc ID RHV 1044. This affidavit details various policies and process improvements of this that the city has undertaken or implemented relating to matters relevant to the inquiry's terms of reference, and primarily those policies and process improvements all post-date the disclosure of the Tradewind report. It's also been circulated to all parties, and my understanding is that no participant objects to it being filed as an exhibit without examination. And thus I'd ask that be marked the next exhibit, which is Exhibit 250.
Okay.
Marked as Exhibit 250.
Thank you. Those are the exhibits that Commission Council wished to include. Commissioner, of course, you also have been provided with the written submissions of each of the participants, and I can confirm that those written submissions are posted on the inquiry's website, and they will be part of the inquiry database.
Good. Thank you.
Thank you. Today we have the first 2 participants' oral closing submissions. First, the City of Hamilton's Council will proceed through much of the morning and into the afternoon, and then Dufferin's Council. And tomorrow we will have Golder's Council and Council for Ontario.
Okay.
Thank you. With that, I'm going to turn it over, I believe, to Mr. Letterman.
Good morning, Mr. Commissioner. Can you hear me? There seems to be a bit of a slight echo. Just give us 1 second.
Sure.
Okay, I think we should be okay now.
Okay. Yeah, we're fine. I'm fine at this end.
Okay, great. Thank you. So the City of Hamilton commenced this inquiry in 2019 to investigate the issues identified in the terms of reference with respect to the Red Hill Valley Parkway. And we're going to provide you with our closing submissions this morning. We've prepared a PowerPoint slide deck that will guide our submissions, and I'll explain how we're dividing up the different issues amongst our team. So if I just pull up the slide deck here, you'll see that if we go to the first slide, we're going to be breaking this up so that I'm going to provide a little bit of an overview. Mr. Chen will address the points and the evidence regarding safety of the Red Hill broadly. Ms. Contractor will speak to the maintenance and improvement the Red Hill and the steps that have been taken in respect of that. And finally, Ms. Talebi will speak to improvements to the city's policies and procedures that has come out in the form of the evidence during the course of this inquiry. Let me just begin, if I could, by saying a few words about the fact that there were other ways that the city could have investigated the issues in this inquiry. But City Council chose to proceed with this judicial inquiry process in the interest of accountability and transparency, and to maintain the trust of the public. And I think, as you've heard over the several months of evidence, that the city of Hamilton has demonstrated its full commitment to this inquiry process since it was commenced in April of 2019. Through the efforts of Commission Council and their team, as well as the other participants, the inquiry has received, as you know, significant amounts of evidence on the issues related to the terms of reference. I do want to, just looking at this slide, you can see that over 131,000 documents were produced, 64,000 of which were city documents. There were prep sessions and interviews of 107 witnesses, including 55 from the city. This inquiry received evidence from 75 fact and expert witnesses. And as you know, we have completed 85 hearing days in this inquiry. I do want to just stop for a moment and on a note of gratitude, thank Commission Council, and in particular, Ms. Lawrence and Mr. Lewis and their entire team for leading this comprehensive inquiry through all stages and with a tremendous degree of professionalism. So that I just wanted to, on behalf of the city and all of the legal counsel involved, just express that note of gratitude. I do want to speak about the terms of reference, and as you know, they are the guiding principles for this inquiry. And each term of reference posed specific questions that the inquiry is tasked with investigating. City Council had identified 24 questions, which we categorize effectively into 6 categories. The first category, category 1, really relates to the Tradewind report and inquires about the individuals who received a copy of the Tradewind report, who were advised of the report or the information contained in it when it came in 2014. Asks about any individuals who are responsible for any failure to disclose a copy of the report or the information and recommendations contained in it to City Council. It also asks about the individuals who received a copy of the report or advised of the report or the information and recommendations in the 2018 timeframe. And I think it is clear that although the Tradewind report was not provided to City Council until 2019, we do intend to spend the majority of our closing submissions today addressing the impact of any non-disclosure of that report on the safety of the Red Hill. And that really deals with the next 5 categories of the terms of reference. Category 2 deals with the role of friction in collisions. And based on the terms of reference, these are the questions that really address the standards of acceptable levels of friction in Ontario for Ontario roadways, the friction testing conducted by the MTO, whether information about friction levels on roadways in Ontario is publicly available, and the role of friction in collisions, particularly when compared to other factors such as driver behavior, lighting, weather conditions, on the impact of that on collisions on the Red Hill. Category 3 really broadly deals with the terms of reference relating to safety of the Red Hill and whether there was any potential risk to road users as a result of the failure to disclose the trade wind report, the implications of the contents of the report regarding safety, and whether the failure to disclose the trade wind report or the contents therein contributed to accidents, injuries, or fatalities on the Red Hill. Also related to the determination of safety on the Red Hill, the questions that are posed in these category of terms of reference address the contents and disclosure of the MTO report, its implications on the safety of the Red Hill, and any friction testing, asphalt testing, and general road safety reviews and assessments conducted on the Red Hill by the MTO. The fourth category addresses the steps taken by the city to monitor and improve safety on the Red Hill. And quite apart from any lack of disclosure of the trade wind report, the questions that are posed in the terms of reference relating to this topic relate to further friction testing, asphalt assessments, and general road safety reviews, and any assessments conducted on the Red Hill and the results of consultant reports obtained by the city in that regard. Fifth, we will talk about the steps taken by city staff after the discovery of the trade wind report in 2018 by Mr. McGuire. And the questions that arise from the terms of reference here address the discovery of the trade wind report in 2018, the steps to disclose the report once it was discovered in 2018, and whether there was any negligence, malfeasance, or misconduct in failing to disclose the report or the information and recommendations contained in it, whether in 2014 and also once it was discovered or brought to Mr. McGuire's attention in 2018. Lastly, we will deal with category 6, which deals with the city's bylaws, policies, and procedures. And from the terms of reference, these are questions that consider whether the bylaws, policies, and procedures that were in place in 2014 would impact disclosure of the trade wind report within city staff and city council, and the changes to the city's bylaws, policies, and procedures to prevent any future incidents of non-disclosure of significant information to city council. So that's broadly, Mr. Commissioner, the categories of the information and what we intend to address before you today in our closing submissions. And as I said at the outset, just in terms of a roadmap for that, I will deal briefly with the evidence relating to the limited disclosure of the trade wind report. Mr. Chen will then deal with categories 2 and 4, which is the road safety and pavement friction issues. Ms. Contractor will deal with categories 2 and 5 relating to actions and steps that the city took to monitor and improve safety on the Red Hill, as well as the impact of the discovery of the trade wind report in 2018. And then lastly, Ms. Talebi will address the steps the city has taken to improve its procedures and policies. So let me just say a few words about the trade wind report and that issue. The inquiry has heard significant evidence on the disclosure of the trade wind report and the information contained therein. And I don't intend to provide a comprehensive summary of that evidence and only seek to highlight a few pieces that I think are material pieces of evidence that this inquiry heard during the course of this proceeding that addresses those specific questions that have been raised in the terms of reference. It does appear, based on the information and the evidence that's been brought forward, that there was only limited disclosure of the trade wind report or the information contained therein prior to August 2017. However, I think, as you'll hear from my colleagues in the way in which they deal with their submissions, the evidence would tend to indicate that there was no significant impact on the safety performance of the Red Hill in light of the limited disclosure of the trade wind report. And they'll deal with those points more specifically based on the evidence that this inquiry heard. But I do have this slide up just to give you that chronology that sets out the receipt of the trade wind report, that in November of 2013, Golder had, after having retained Tradewind to perform friction testing, that testing took place in late November 2013 using the measurement device called the grip tester. Tradewind provided Golder with its report and recommendations based on the friction guidelines from the United Kingdom. And my colleagues will speak to those issues, including the significance of those friction values and the UK guidelines in greater detail. I just wanted to highlight that just in terms of the chronology about the receipt of the Tradewind report. It was in January of 2014.
Just to be clear, that slide says Tradewind provided Golder its report and recommendations in November, but that's not accurate, is it?
No, pardon me. That's when the Golder draft report had appended the.
No, that's all it's in January.
That's right. It's in January that
Right.
Mr. Moore
The slide that says Tradewind provided Golder with its report and recommendations under November 13 is not correct.
That's right. I actually don't have that detail in front of me as to when Tradewind provided Golder with its report. But there is the
January 26th. If I'm not, council can, Golder can perhaps correct us if that's wrong.
Thank you. So I'd have to check the chronology. It's January 26th is the Tradewind report. Yes, thank you.
Yeah, I think January 24th was when the short form information was provided over the telephone. January 26th when the report was delivered.
That's correct, Commissioner.
Okay.
Yes, certainly January 2014, Mr. Commissioner, is when Mr. Moore received the draft Golder report that appended the Tradewind report to it.
Absolutely.
I think the November 2013 reference is the dates that Tradewind had. I think the report itself, there was a November 2013 date on that. I just don't have it at my fingertips, but
Okay.
it was only, the key piece of this is that it was only received by Mr. Moore in January of 2014.
Yes.
Okay. Now, it does appear that between January 2014 and 2017, the Tradewind report itself was not circulated amongst the public works group. But there were pieces of evidence that you heard during the course of this inquiry that indicated that Mr. Moore did share the information, or at least some of the information regarding the Tradewin report with city staff. And I do want to just highlight for you a couple of those references, if I could. Just by way of example, on February 15, 2016, Mr. Moore advised Mr. Ferguson and Mr. Lupton that friction testing was completed and that he was still trying to get the analysis for it to put the results into context, particularly as to how they relate to other highways of a similar type. You heard evidence that friction testing results was added as an agenda item for a meeting in May 2017 entitled RHVP/Link Plan, which was attended by senior members of the Public Works leadership team, which included Mr. Dan McKinnon, who was the GM of Public Works at the time, Gary Moore, who was the Director of Engineering Services, and Betty Matthews Malone. And in addition to those two, to the sharing with those groups within Public Works, Mr. Moore, you heard the evidence, shared the testing results with Brian Malone of SEMA in August 2015 in the context of the 2015 SEMA report. Although, to be clear, I think the evidence showed that Mr. Moore provided just the average friction numbers and the friction range numbers to Mr. Malone in that 2015 timeframe. Mr. Moore also provided, as you heard the evidence, a copy of the Tradewin report to the city's external legal counsel in August of 2017 at their request. I think because there was a request for it to be produced in the usual course of litigation. And then with respect to the 2018 time period, you heard evidence that indicated that Mr. McGuire learned of the Tradewin report on September 26, 2018. However, I think we acknowledge that there was some evidence which suggests that Mr. McGuire may have learned of the report in August of 2018 instead. There was some lack of clarity on the evidence on that point. The evidence also showed that Mr. McGuire, upon obtaining a copy of the Tradewin report, subsequently shared that report with senior members of Public Works, which included Mr. Edward Soldo, Mr. Dan McKinnon, Ms. Susan Jacob, and Mr. Mike Zegarak. In addition, City of Hamilton Legal Services, which included Ms. Nicole Audie, Ms. Berdina McNeil, and Mr. Ron Zabo, were subsequently made aware of and had access to the Tradewin report as a result of a Freedom of Information request. And as you heard the evidence, Mr. Commissioner, over the next few months in that timeframe in 2018, Public Works staff, in consultation with legal services, made efforts to collect information surrounding the contents and implications of the Tradewin report for the purpose of presenting a comprehensive report to City Council. You also heard that following a meeting with the mayor in December 8, I think it was on December 18, 2018, staff were advised against bringing an urgent report to council in a piecemeal fashion. And the mayor directed staff to ensure that they had all the information before briefing City Council with the matter. And then indeed on January 23, 2019, a closed session was held to advise council with respect to the Tradewind report and any liability, any related liability that may arise from the release of the report in light of the pending FOI request. And then on February 6, 2019, City Council had a comprehensive briefing on the history of the Tradewind report, as well as the various improvements implemented on the Red Hill since the Tradewind report was authored. And although, as I mentioned above, although the Tradewind report was not widely disclosed when it was received, the scope of this inquiry, Mr. Commissioner, has allowed a comprehensive investigation and inquiry into the contents and implications of that report, and to consider whether any failure to circulate the information contained in that report or the report itself posed a safety risk with respect to the safety performance of the Red Hill Valley Parkway. And as I expect that you are going to hear from my colleagues, they will address the evidence about whether the lack of disclosure or limited disclosure of that Tradewind report or the information contained in it had any material effect on the safety of the Red Hill. With that, I will turn it over to Mr. Chen, but before I do want to also, I noted with gratitude at the outset of my submissions, the assistance and the hard work of the Commission Council team, but I certainly don't mean to exclude you, Mr. Commissioner, who has sat through patiently and has heard a number of witnesses testify and dealing and cooperating with council throughout this inquiry. And so just as a note of thanks to you, I know this has been a long road. It has been a lengthy inquiry, and we are grateful to you for your attentiveness to the issues in this inquiry, and do want to thank you for that.
Thank you, Mr. Letterman. It goes with the territory.
Thank you. Okay, with that, I'm going to pass it over to Mr. Chen. And we just give us a moment, if you would, as we just have to, I'm going to move seats and he'll take over from here.
Mr. Chen, if you were speaking, at least I can't hear it. I don't know whether other council can hear it or not.
Can you hear me now, Mr. Commissioner?
Yes, loud and clear.
Okay, perfect. I had started originally by also extending my thanks to everyone, but it's less impactful now that my colleagues have heard it. In any event, as Mr. Ledman indicated, I will primarily be speaking to the road safety and friction evidence that we heard over the course of the inquiry, which substantially was the evidence that was tendered by the friction and road safety experts. So I think I have the benefit of that evidence being fresh somewhat fresh in our minds. Some of the factual evidence related to these issues also involved Golder and the MTO. So you will hear a little bit about them in my submissions. In terms of a roadmap, I will first touch briefly on background and a bit on planning, design, and construction. But my submissions will largely focus on the topics related to traffic safety, such as design guides and collision rates. And I'll then talk about friction, which of course is a very broad topic that includes things like its role in collisions, the results that were taken over the years, and others. And then I'll hand it over to Ms. Contractor. So starting with very brief background, as we all know, the Red Hill Valley Parkway is an urban freeway in the city of Hamilton. It's approximately 7.5 kilometers long and located in an environmentally sensitive area. It runs north to south and is the link between Highway 403 and the QEW. And of course, the Lincoln Alexander Parkway, or the link, runs east-west and connects Highway 403 with the Red Hill Valley Parkway. So with respect to planning, design, and construction, there was a fair bit of evidence on each of these topics. Planning, design, and construction of the Red Hill spanned from 1980s until its completion in 2007. And we heard evidence that the Red Hill was constructed with an experienced team consisting of managers, consultants, contractors, and city staff involvement. In our view, what was under the microscope during that portion of the hearing are the three bullets that you see on the slide: the quality of the aggregates, the question of the quality and appropriateness of the surface layer, which was stone mastic asphalt or SMA, and the work quality of the construction work. On each of those topics, the city's view is that what the evidence strongly shows is that first, that the aggregates used for the surface layer was high quality and fully adequate for its use on the Red Hill. That the mix design used for the SMA is current and appropriate. And that the placement of the SMA was properly undertaken. And the significance of this is that there were no anomalies or issues that would detrimentally impact the friction on the Red Hill Valley Parkway. Now, I'm quite certain that you'll hear about these topics a bit more from some of the other participants, but that is all I intended to say on this topic. So just moving forward now, one of the topics that occupy this inquiry was traffic safety or road safety. And you heard from both experts and fact witnesses. I'll be sticking mostly with the experts. If you can go to the next slide. Just from an expert perspective, you heard from two experts, both of whom are professional engineers of Ontario and other provinces. So on the left, Mr. Dewan Kareem was retained by the city of Hamilton. He's the practice lead of the Transportation and Engineering and Safety Group at the consulting firm 30FE. Mr. Russell Brownlee was retained by Commission Counsel. Mr. Brownlee spent a decade of his career also at 30FE, and he is now the president of the True North Safety Group. Considering their credentials, and I don't plan on going through them, and their previous experiences, they were both, we say, well qualified to address the mandate that was given to them in this inquiry. Mr. Brownlee and Mr. Kareem primarily addressed three broad topics on roadway safety. You see that on this slide, and certainly they did address some other issues, but here they looked at the anomalous safety review, questions of driver expectations, and collision rates. There is one topic that the roadway experts and the friction experts all opined on, and that's the question of contributory factors to wet road crashes. I'll make brief submissions on that altogether when I go into some of the friction issues. So Mr. Brownlee and Mr. Kareem substantially disagreed on each of these topics. And for today's purpose, I'll be touching on these topics at a high level. And addressing really where I think the evidence was left off. So turning first to the safety review that was undertaken, as you will recall, Mr. Brownlee was asked to review whether the Red Hill Valley Parkway in its design followed the MTO's 1985 geometric design guide. And there's no dispute that the Red Hill Valley Parkway was designed with reference to the 1985 design guide. So both Mr. Kareem and Mr. Brownlee agree on how to interpret or understand the application of design guides. And I think you have this point from the evidence, but it is worth repeating that nominal safety is a consideration of whether a road design element meets minimum design criteria. That's what was undertaken. But roadway safety is not a matter of simply ticking off a box or meeting the minimum values of a design guide. Both experts agree that following a guideline does not mean a highway is safe. They also agree that not following a guideline does not make a highway unsafe. And so with respect to design guides and the application of it, there are of course many situations, because of environmental constraints that make following the guidelines simply impossible. That's something that came out of the evidence. So just with that in mind, I'll turn to the application of it. So ultimately, Mr. Brownlee's analysis showed that the Red Hill, by and large, followed the minimum design values set out in the MTO design guide. And some of the more key criteria that we talked about, he indicated that the design values for the design speed were met. The design values for the horizontal alignment or curvature were also met, except for one where Mr. Brownlee didn't have enough information to make a determination. And just along those lines, there are some aspects like site distance that Mr. Brownlee couldn't confirm for certain logistical reasons or reasons related to his scope of his mandate. So it was really the interchange spacing that did not, in most cases, follow the design values for a full interchange spacing for an urban freeway. And on that aspect, with respect to an urban freeway, the spacing, the interchange spacing is generally, not always, but generally in the range of 2 kilometers to 3 kilometers. So Mr. Brownlee, when he looks at this, he does somewhat of a rudimentary analysis. He simply looks at, is it above, is the spacing above 2 kilometers or below 2 kilometers? But that analysis doesn't quite present the full picture on interchange spacing. And so Mr. Kareem did a deeper dive into the question of interchange spacing. And he gave a bit more insight in 3 ways. And the first and second ways are really comparisons that he looked at. Right, you'll recall, Mr. Commissioner, that he looked at minimum spacing values set out in other resources, and he noted a rule of thumb of 1.6 kilometers. He looked at guidelines from other countries, which varied from 1 kilometer to 2 kilometers, to put in perspective the interchange spacing on the Red Hill Valley Parkway. He also looked at interchange spacing of peer highways, right, and peer segments, so such as the DVP and Highway 7, where those are dense urban freeways and with frequent arterial spacing. And so in those cases, the average spacing was similar. And Mr. Brownlee did try to challenge whether the right comparator was used, as you would expect in an analysis of this type. But Mr. Kareem emphasized that it's not about comparing the entire roadway. So he's not comparing the entire Red Hill to the entire Don Valley Parkway. He's selecting what is comparable based on segments and the relevant segments. In a comparison like that, where you're comparing like or similar segments, is a type of analysis I think Mr. Brownlee would agree with. So the third, and I would say the most important point, is that Mr. Kareem looks at what the MTO design guide says on interchange spacing in its entirety, not just a partial statement from the design guide. What Mr. Kareem highlights is that the guidance from the MTO design guide is that where the 2 kilometer spacing can't be met, then the suggestion is partial interchanges or an alternative configuration. So on that aspect, Mr. Kareem's evidence was that the Red Hill employed both partial interchanges and alternative configurations. And Mr. Brownlee doesn't comment on this point. And so you recall Mr. Kareem talked about partial interchanges, so one less ramp So 4 ramps instead of 6 ramps, which you'll see on the link. Mr. Kareem talked about the inclusion of traffic signals to delay traffic. So when Mr. Kareem undertook that analysis, looking at the comparisons with other guidelines from other jurisdictions, peer highways, and also the guidance on what to do based on the MTO guide when the 2 kilometer spacing can't be met. In his view, he doesn't see there being a deviation from the design value set out in the MTO design guide. And again, as I say, the forceful aspect of that is the 3rd point, where he actually looks at the wording and what the MTO design guide has suggested.
All of that being true, it's not suggested that these alternative approaches are a perfect solution.
So I don't know that the MTO design guide purports to set out a perfect solution, but I think the design guide speaks to 2 different situations. One is the recognition that an urban freeway, often because the arterial roads are already built, that you can't meet the 2 kilometer minimum. So do this. And so that's, and in Mr. Kareem's view, the planners had that in mind, and you know, they took steps for sure to address that situation. What flows from, and that's all I wanted to say about the MTO design guide, as in my view, it was the interchange spacing. When we're doing a nominal safety analysis, it was the interchange spacing that raised the most questions. So what flows from this discussion about how the Red Hill was designed is the topic of driver expectations. And how does the design affect or influence driver expectations? You know, you can meet the design values. And we've heard evidence of that, but it can have an impact based on where you land within the range of the design values. And that was a point of disagreement between Mr. Brownlee and Mr. Kareem. And we spent a fair bit of time in the city's written closing submissions addressing this issue. But very briefly, of course, driver expectancy is really about a driver's readiness to respond to situations and events on the roadway, and it's formed by, you know, what they see in front of them and their past experiences. So we have emphasized in the written closings how expectations can be and are actively managed on the Red Hill, that would primarily be through signage. Certainly there's some dispute by Mr. Brownlee about the effectiveness of some of those steps to manage expectations. But in reality, it's a difficult thing to actually measure and quantify. And, you know, Mr. Kareem points out that a substantive analysis wasn't undertaken. I think the key point is something that Mr. Brownlee admits, which is that any alleged expectancy violation, they are just things that could or may have an effect on the driver. I don't think he was purporting to say that these things actually did have an effect on the driver, since no analysis was actually undertaken to confirm whether that was the case for any particular driver. So now moving to the next slide. Which is the collision rate on the Red Hill Valley Parkway. And this was a topic that was discussed at various points in the inquiry, not just phase 2, of course. The collision rate is an important factor in looking at roadway safety and comparing with other highways or parts of a highway. And it's most informative when the comparison is between comparable highways or comparable segments of a highway. The experts agree on that basic point, that you need an apples to apples comparison. And so for ease of reference and discussion, and as you have seen in the city's written submissions, the focus here is on the collision rate that was calculated by SEMA in 2019. And when we look at those numbers, we say it shows comparable collision rates to its peer highways by segment, at least. And what that means is that the Red Hill Valley Parkway is not, some sort of an outlier highway in Ontario. In comparing the collision rates, we look at two rough groups. And we can just go to the next slide. You'll see the SEMA collision rates, the ones that they calculated for the Red Hill on the left side, and then the comparative highways on the right side. So within each highway, we look at the figures in two rough groups, and just might be fast and loose with my terms here, but there are the tangent segments and the curvature segments. So for the Red Hill, we know that the curvature is tighter from segments from Green Hill to Barton. That includes, of course, the King Street interchange. And what we see there, not surprisingly based on what is expected, is a higher collision rate at those segments than where the roadway is not defined by curvature. So the collision rate ranges from 0.94 to 1.87. Otherwise, the collision rates range from 0.59 to 0.72. And so comparing those ranges, for example, to Highway 406, the collision rate for the segment more defined by curvature is 1.76. And that's the Westchester and 4th Avenue segment. And the other segments are lower, between 0.32 and 0.60. So what we see is that the collision rates are different, but within the same range. And what we draw from that is we can't say one highway is significantly more or less safe than the other. Had the Red Hill collision rates been significantly higher, for example, then that would be information to take into account regarding safety.
So I'm just have to stop for a second here. Your position is that of all of these other segments, the only comparable segment to Green Hill to Barton is the Westchester to 4th Avenue on Highway 406. Is that correct?
That is an example of.
No, not an example. Is that because all the other numbers are substantially lower?
For all the other highways, Mr. Commissioner?
Correct. All the other segments of all the other highways have substantially lower collision rates than the Green Hill to Barton segment of the Red Hill Valley.
So the reason why we were comparing the Green Hill and Barton to the Westchester and 4th Avenue is because those are both, as I was mentioning before, similar segments. So well, we wouldn't be.
My question is, we go back and see exactly what the evidence of that being a similar segment is, but is your position that's the only similar segment?
that, well, from what the evidence has shown, and you know, the reason why I point out the Westchester and Fourth Avenue is because there is evidence that the Westchester and Fourth Avenue curvature, or that segment, is most similar to the Red Hill.
Well, the evidence that you're referring to is Mr. Ferguson's, if I can call it,
Right.
anecdotal evidence, not expert evidence. And it also was tied in to the 2018 SEMA numbers, which were different, and included as a similar segment, Fourth Avenue to QEW in some manner or other, which you may or may not fully understand. But then in going to 2019, you've dropped the other segment and focused solely on Westchester to Fourth Avenue.
So I'm not dropping the other segments. We are looking at the collision rates for the other segments.
Yeah.
As I say, is 0.59 to 0.77, and comparing that to the segments that are not defined by curvature, we say that there's a similar range. And I'm not sure that the years matter. It's really the focus on the
Okay.
the design, the geometric
Right.
design of.
But the only evidence that you have with respect to any comparable segment is Mr. Ferguson's anecdotal evidence that this particular segment seems to be comparable in his mind, correct?
Yeah, I believe that. I believe that is correct, subject to any of my colleagues telling me that that's not right. But the evidence does largely come from Mr. Ferguson.
Whereas SEMA obviously thought that this entire table was relevant.
Sorry, could you repeat that?
SEMA felt that the segmented table was relevant, as well as the aggregate numbers. I'm not sure why I would conclude that the relevant portion of the RHVP is comparable in the manner that you've suggested, solely on the basis of the limited evidence that's before me with respect to this one segment.
So we're not saying that we should just be looking at this one segment. We are looking at the other segments as well, and
yeah, but the reality is that this is I apologize.
no problem.
The reality is that the segment that we're most concerned with probably is the Green Hill to Barton segment of this roadway.
We look at it as, well, kind of all segments, and comparing the curvature segments with the curvature segments of another highway, and I don't think there's a dispute amongst the experts or SEMA really that if you're doing a comparison and you're trying to determine an overrepresentation of collisions, you would be looking at it from, you know, the apples to apples
Right.
comparison. So we do focus, of course, on the Green Hill to the King segment, but equally we're looking at the other segments. And I appreciate that, you know, Mr. Ferguson did not testify as an expert, but he does come to this with expertise He's not simply a layperson. He's been in his role, and he understands traffic safety, as that's his job.
Right. The other question that does come to mind is perhaps Westchester to Fourth Avenue is similarly challenging, let me put that term as a neutral term, but that doesn't necessarily mean that one should take great comfort from that. We don't know anything about that segment, whether, for example, it isn't also an area of concern for the MTO.
And I take your point, but I think directionally we can expect that where there's curves, there's a higher collision rate, and I think your point is that, well, maybe they're both high.
Yes.
And I think that's valid, but this is what we're working with, and there's no indication, of course, one way or the other, but we do know it's similar.
Okay.
So that is the traffic safety topics that I wanted to touch on, and I'll come back to one of the topics of the contributory factors to wet road collisions later on, but now I want to turn to friction. So pavement friction was, of course, a core focus of this inquiry. A number of fact and expert witnesses testified on the topic, generally and very specifically. In the city's closing submissions, we addressed a number of issues, and it's not necessary for me to go through all of them. So I will be touching mainly on the ones that we see are core to answering some of the terms of reference. So on the topic of friction, you heard primarily from two experts. On the left, David Hine, who was retained by the city. He's worked in pavement friction for over 3 decades, primarily in Ontario, and at various engineering firms that have pavement specialties, including pavement friction. Dr. Gerardo Flinch, who was retained by the commission. He's a professor at Virginia Polytechnic Institute and State University, and of course, don't mean to leave Dr. Hassan Baj out. The only reason why he's not up here is because he had a more limited role, speaking about the aggregate and polished stone value and that side of things, in case Ms. Roberts is wondering. So there's no question that both Mr. Hine and Dr. Flinch are both eminently qualified on pavement friction matters, but their expertise does diverge. We say where Mr. Hine has the upper hand is the breadth of his Canadian experience with respect to friction measurement and friction management. And Dr. Flinch, readily admits that his experience in Canada is limited. So Mr. Hine has testified about his extensive pavement experience regarding pavement friction testing in Canada, and specifically in Ontario. His use of friction testing devices, from the locked wheel tester to the grip tester, and his experience working with different pavement restoration techniques, like shot blasting and microsurfacing. And we say Mr. Hine's Canadian-based expertise matters because this inquiry is about an Ontario roadway. So we're dealing with a Canadian aggregate, friction numbers on an Ontario roadway and friction value interpretation in that context amongst other issues. So as you consider the opinions of these experts, Mr. Commissioner, it's important to keep in mind, the source of their expertise and experience, which forms the basis of their particular opinion. So with that in mind, if you can go to the next slide on the role of friction. One of the key issues in this inquiry is the role of friction in collisions. So it's important to recognize, and there's no dispute about this, that deficient friction or low friction is rarely the main cause of a collision. That said, friction can certainly be a potential contributing factor, but by no means does it stand out from the other potential contributing factors. All the experts agree that collisions are complex. Let's just go to the next slide. They are caused by a number of factors, and friction is just one of them. In his report, Mr. Hine has provided a table that sets out over 25 potential contributing factors to collisions. Of course, every accident has its own causes, and it takes some investigative work to determine what those contributing causes actually are. So in our view, these basic propositions are important to appreciate and understand in the context of considering what friction work, for example, may be needed or not. So moving beyond the role of friction now to the question of, well, how do we understand friction values? What do we do in Ontario? We heard significant evidence on what is known as the investigatory level, FN30, which is commonly used in Ontario and in particular by the MTO. And FN30 is, of course, engaged with friction values taken with measured or taken with a locked wheel tester. Separately, for which there is no guidance in Ontario, values obtained with the grip tester device. There was evidence on using guidelines instead that were developed for roads in the UK. And that dichotomy is what I turn to next. You'll see this slide.
Can I just stop you for a second? I took something slightly different from the evidence of the MTO, which relates to the context in which the testing takes place. In the context of testing for material on the DSM list, you're quite right. They're comfortable, absent anything else, that FN 30 plus is acceptable. If it were below that, I guess it would depend on how far below, but that would start raising questions about the aggregate. But in the context of the broader issue of traffic safety, where from the MTO's perspective, that's sourced by the regions presenting the problem. Testing of FN 30 has a rather more flexible kind of application. Something below FN 30 might merit more consideration depending upon the circumstances that have prompted concern for the collision experience of the particular segment at issue that's been raised by the region, but also depending upon the nature of the area, something above FN 30 could also be considered a cause for investigation as to whether it is a contributing factor. Certainly not the main factor. I think that was more or less agreed generally, but that it could have some consideration as a potential contributing factor. Do you want to speak to that?
Yeah, and I think the experts would agree on that you can be below 30, you can be below, you can be above 30. But as we've heard Mr. Hine talk about, he doesn't just use FN30 as looking at aggregates. In his view, in his expertise, FN30 is used to assess the friction levels, and as an investigatory level of, if it's below, we may investigate. That said, I think the concept of friction demand is separate from the investigatory level, and that is also something I will be discussing. But in Ontario, and I think the MTO evidence does bear this out a bit, but certainly Mr. Hine has talked about it, is that FN30 is a guideline to use when you are assessing locked wheel values. So if we can actually just go back one slide. If I could quickly summarize the positions of the expert. With regards to FN30, the Canadian expert, Mr. Hine, as I say, strongly endorses the use of FN30 to understand and interpret friction values. Dr. Flinch doesn't quite take a position on the use of FN30. And with regards to the UK guideline, Mr. Hine doesn't see value in using them in Ontario to interpret friction values that were taken using the grip tester. Dr. Flinch believes that there is value in referring to the UK guidelines because no guideline exists in Ontario for the grip tester. And I'll get into the details of that a bit more, but just to lay out what I think the positions are. The city's view is that Mr. Hine's approach should be preferred, as it is based on local practices and local knowledge. So first, why is FN30 appropriate? There are many reasons for the case of applying FN30, and we have set those out in the city's written submissions. And I've already mentioned this. FN30 or greater is considered to be an acceptable friction value, and generally results below FN30 may merit further investigation. And I know you have that point, Mr. Commissioner. As Mr. Hine testified, FN30 is the prevailing guideline applied in respect of roadway friction in Ontario, and that's not meant to suggest that there is some other guideline. That is it in Ontario. It's also accepted that the province of Ontario has not established a friction management system for provincial or municipal roads. Certainly that would provide some assistance. But we also recognize that in Canada as a whole, there are no published standards, so Ontario is not alone in that. And importantly, there's no suggestion that FN30 should not be used to understand friction values taken by the locked wheel. Certainly the MTO, I don't think they say that. Neither does Dr. Flinch. Dr. Flinch does not say that FN30 is not satisfactory as an investigatory level, nor has he suggested that it's just not to be used And Mr. Hine referred to the US, a couple of states, what investigatory levels they use. Those figures hover below and above FN30. FN30 sits roughly in the middle of the comparisons that Mr. Hine located. So in our view, there's no ambiguity in the evidence on the purpose and value of FN30. Where the expert views depart is the purpose and value of the grip tested results and the application of the guidelines from the UK guideline. So what do the experts say on this? Mr. Hines' view is that even if you have grip tester results, like in the trading report, you should not examine them using guidelines that were developed in the UK for the UK. In contrast, Dr. Flinch believes that there is value in relying on the UK values because you don't have a criteria in Ontario otherwise to assess those values against. Dr. Flinch is correct that there is no guideline in Ontario to understand those values. But we say there's no criteria because friction testing, as we've heard Mr. Hine talk about extensively in Ontario, is done using the locked wheel tester. Mr. Hine, in his decades of experience, has not seen the application of the UK guidelines to evaluate friction values on a roadway in Canada, and no one has questioned that that evidence. Of course, Mr. Hine was surprised that Golder went down that road. So the situation here with the grip tester results is a foreign one, and trying to address it now by using a foreign guideline, we say, is not the answer. In terms of why foreign guideline is inapplicable, the undisputed evidence is that the UK guidelines were developed for the local conditions and environment of the UK, their specific asphalt designs, their aggregates, their vehicle types, and a host of other factors.
So,
Mr.
Mr. Chen,
Yep.
is the city's position that the trade wind report is simply of no value?
No, that is not the position, and we rely on what Mr. Hine has said in his evidence, that he's not looking at individual values because there is no criteria.
Right.
What he's doing with the report and the values is looking at them comparatively. Are there significant deviations that he sees? That's the main use of it in his view. So it's not, and I think Mr. Lewis had asked Mr. Hine this question, that you wouldn't just put it aside. Mr. Hine says is that you would look at it and see where the values may differ drastically, and he didn't see any significant deviations when he looked at the results. So, and just to continue on the point of why the UK guideline is inapplicable and should not be used, because of the differences, because the UK guidelines were developed for the UK, Mr. Hine says that if we don't do that verification, if we don't do that analysis, that it can be applied here, then we shouldn't use it. Dr. Flinch says effectively, well, let's just use it this time. But that opinion is tough to square with his other opinion that you wouldn't adopt a standard from another country without first verifying that it can be applied to your own country. So Dr. Flinch acknowledges that he doesn't know if the UK guidelines are fit for our Ontario roads and you should verify it first, but at the same time, he says you should use it. Dr. Flinch makes that statement without undertaking any analysis or taking any steps to satisfy himself that there is some conformance, which I appreciate is a difficult task given his unfamiliarity with Ontario. There's no evidence on his familiarity with how the UK guidelines were developed. He doesn't point to other jurisdictions that casually rely on the UK guidelines to assess their roadways. So from the evidence, we say there appears to be little, if any, support for Dr. Flinch's suggestion that it's fine to use it here. But aside from unreliability and inapplicability, what else is the problem? Mr. Hines' evidence is helpful on that. And in his view, it creates confusion. Right? Here, Mr. Hines says that if you apply the UK guidelines and you apply the FN30, you actually get two different answers. Right? He says that the UK guidelines say that action is needed. That's not the case when you apply FN30. And just to be clear, he makes that statement obviously by looking at the 2014 MTO results. So you can see what the practical effect is when you use two different guidelines, one of which has not been tested or verified. So ultimately, Mr. Hine comes at this question in a reasonable manner, focused on local practices, focused on certainty over ambiguity, and prioritizing engineering rigor. And for those reasons that Mr. Hines' opinion should be preferred.
But Mr. Hines said if he'd received that document, you asked him about the concerns, and it was asked about the concerns, and he said he would indeed look for higher or lower numbers and try to see whether that's explicable in terms of the, I'm going to generalize now, the roadway surface. He was asked, did he see anything that troubled him? The answer is no. It wouldn't concern him until he looked at the road, but he would have looked at the road having received that report.
So he would have looked at so for the values that are in the 20s, I think was what he was referring to. So he didn't, so just stepping back, he didn't see any significant deviations, but he did see some values in the 20s. So one thing he may have undertaken is a field inspection on those locations where
Correct.
the values were.
That's what he's.
Yeah.
The real question here is not so much in the abstract as in the application. What should have happened when this report was received? That at least is one of the central questions in this inquiry. And I think Mr. Hine and Mr. Flinch, or Dr. Flinch, essentially were saying the same thing in this one. They may come at it slightly differently, but they were basically saying that some further investigation in the field, or in Mr. Flinch's case, further testing, others may say the same thing, would have been warranted. Do you want to speak to that?
I think Dr. Flinch goes much further.
Well, whatever Dr. Flinch says, you're relying at this point on Mr. Hine, and he said at a minimum a field examination would have been warranted.
So Dr. Flint, yeah, Dr. Flinch says that, I think Dr. Flinch says that field investigation and probably friction testing as well. He comes at that though from the UK guidelines.
Right.
Mr. Hine takes a somewhat different view in that he's only looking at the 20s, and he may go out and look at the pavement. He's not committing to any additional friction testing as being necessary, but he also said he may have done it the following year with a locked wheel
Right.
tester.
Right.
So we see the obligations as being different, and of course it comes from what guideline they're looking at. And had locked wheel testing been done in 2014, of course we have the 2014 results, which Mr. Hines sees as being acceptable to him. I note that it's 11 and
Mhm.
it escapes me when we take the break.
Well, it's a good guess,
Yeah.
Mr. Chen. We normally take our break at 11. So if this is a convenient time to do so, let's take a 15-minute break.
Perfect. Thank
Okay,
you.
back in 11:15.
Hello.
Thank you, Mr. Commissioner. May I proceed?
Yes, please do, Mr. Chen.
So we were, just before the break, we were talking about the grip test results and Mr. Hines' approach. Just to highlight those points. Of course, he's looking at significant deviations, which we talked about in his evidence that he didn't see significant deviations, and that he may have undertaken some sort of a field inspection with respect to the values in the 20s. Another important point that comes out of that discussion is that Mr. Hine would have no basis and no reason to link the values in the 20s to the occurrence of weather accidents on the Red Hill at that point. And he had talked about the limits of the 2013 SEMA study. Mr. Hine was also asked in cross-examination about his view of the grip tested results by Mr. Lewis, that wouldn't it be the case that FN values would actually be lower than the grip tested values, since sometimes directionally that is the case. And Mr. Hines' response to that was that it would be possible, but he didn't know for sure. So it's not an inference that can be drawn. There's no evidence as to whether it's always the case on every single pavement that FN values would be lower than grip or GN values. He wasn't shown any locked wheel results from 2014 that in fact showed the type of directionally lower values that I think the principles may suggest. I'd intended on talking about the locked wheel results first, so let me just go to that now, which is the next slide. I think these are straightforward. There isn't really much dispute about them in the evidence. Of course, there's locked wheel testing from 2007 and to 2014, of course, not 2013, and also 2019. And what the evidence shows from the locked wheel results is that the values were acceptable. They were above, on average, FN 30, with the exception of some that were below FN 30 by less than one decimal point when you look at the ARA data from 2019. Mr. Hines' view is that the values just below FN 30, and I'll come to those, are minor and inconsequential. In terms of the arc, what we see on this figure here, the Canadian experts, Mr. Hine and Dr. Baj, agree that the decline is within the norm, and I think Mr. Hine calls it a classic SMA curve, I think the word was. And there's also no dispute that the friction results had leveled off on average above FN 30, either in 2013 or 2014. So I just want to look at the 2019 ARA friction results, which is what Mr. Hine featured in his report. What Mr. Hine is looking for when he's assessing these values is, really values that are in the low 20s, which would be concerning to him, and if there's some sort of a trend. So he looks at the different lanes, and here on the screen, you see northbound lane 1, and the trend here is above FN 30. Going to the next slide, which is northbound lane 2. Here, the obvious question to Mr. Hine was, well, you see a 29.2 at the 2 kilometer mark, which is the third bar from the left. he sees that as an outlier, not a trend. Again, what the trend shows here is above 30. The next slide. Southbound lane 1, similar to northbound lane 1, the trend again above FN 30. And finally, southbound lane 2. Here there are 3 values that are just below FN 30. You'll see that at the 6.5, 5.5, and 5 kilometer mark. Again, Mr. Hines' evidence was that he sees no obvious trends suggesting any localized friction problem. These are minor and inconsequential. I mean, they're 0.3 or 0.4 below the average of FN 30. That said, because there are consecutive numbers, he said he may conduct a visual inspection for pavement irregularities. That's what he might do. But overall, from the friction values, Mr. Hine is not concerned. He sees them as being acceptable. There are no red flags, no safety concerns. And I just point out, as I understand it, that the MTO is of the same view that at least the results from 2007 and 2014 don't show that there are any problematic friction values. There's no extended pattern of low friction numbers or the types of deviations or patterns that might have created concern. And then certainly the city was never advised of any safety concerns arising from the friction results taken by the MTO. That is something the MTO would have done if there were any safety concerns. So just go to the next slide. Keep going. Right. And so I just touched on the first bullet there. The MTO didn't raise any safety concerns. We say the same point could be made with respect to Golder, which we've detailed in the city's closing submissions. With respect to any of the friction values that Golder was aware of, they never advised the city that there was any safety concerns.
So help me out on this, because I think you must be coming at this in a slightly different way from the way I thought we would be looking at this. The MTO, they're looking at these numbers from the point of view of acceptability of the SMA pavement, for which their experience would say FN 30. But so I think that at least I would understand safety concerns to be numbers in the low 20s in that context. But if one of the regions had come to them and said, look, here's this collision history we've got with wet weather accidents. My understanding is the MTO wouldn't necessarily have said, oh, well, with these numbers, there can't be a friction problem. There's some other explanation. They would have said, we should at least consider whether there's a friction problem. Now, do you see this differently?
So,
even though the number is slightly above FN 30. Do you see this any differently?
So no, I think that what you're describing is consistent with the MTO. They do talk about, many of their witnesses talked about friction demand, and it's not always about the 30 if you have additional information.
Right.
And it goes back to the experts also, I think, aligning with the experts' views on that. And the point here is that when the city, the MTO witnesses were questioned as to whether the results raised any safety concerns. And it was a broad question, safety concerns. Their response was that no, it didn't raise any safety concerns. And so they didn't reach out to the city. The friction demand, and I think we kind of touched on this earlier, the friction demand and the FN30 or the investigatory levels are somewhat two different things. And so we've talked, and I will talk about, friction supply and friction demand.
Mhm.
But they are two separate
Sure.
things. And
Okay, so with respect to Golder, again, it seems to me, again, I invite your comments, but the analogous situation for Golder would be because these numbers aren't in the low 30s, low 20s. They don't by themselves. I don't think anybody has suggested that by themselves they reflect a concern for safety in the sense that they can be the principal cause of an accident. But for Golder to be in the same sort of situation as we were just analogizing to the MTO would require that the city advise Golder that they were aware of and concerned with collision experience in one or more areas, which the city never did, as far as I can see. The first time Golder was aware that there was a concern for fatal accidents on the highway seems to have been, in fact, as a result of an email from the city's expert, Mr. Hine, in January of 2018. So is it meaningful to say that Golder didn't raise any safety concerns?
No, so I think there is still meaning to, when we say neither the MTO or Golder raised any safety concerns. And I appreciate that Golder has been pushing that there are not safety experts. And if that is the case, I think that supports why in their recommendations, they haven't suggested or told the city that there is a safety issue when a particular remedy is not taken. I think that there still can be an expectation that you do and should raise if they had any safety concerns with respect to the information that they had at the time. The interesting point about Golder is, of course, they are a consultant and telling us what we should they should be advising us properly. And while they have said that they're not safety experts, I think in the same breath, they've also kind of said they warned the city about skid hazards. So there is a bit of, I think, insincerity there as to what their role is and what they can do and what they should have done for the city.
Okay.
And we've in the evidence, it was explored through various witnesses as to the wording and language, and in the draft Golder report and the Tradewind report, there's just in terms of this point of not raising any safety concerns, there's certainly no urgency expressed in the language. No real specific timelines expressed. Again, no indication of a safety concern, and that's who the city is. That's who the city is relying on for advice. And of course, my colleague will talk about Ms. Baker, but she emphasized those principles. Okay. So with the role of friction and friction values in mind, I want to turn now to remedies and more particularly on something you've asked me about, which is friction supply and
Okay,
friction demand on a particular roadway. Skid resistance can be improved by increasing the supply of friction, for example, by physically addressing the characteristics of the pavement. Skid resistance can also be improved by taking steps to reduce the friction demand. And there was discussion on both sides, the supply and demand, by both experts. Right, the supply topic came up in the context of the recommendations that were made. The demand came up in the context of countermeasures as a way of addressing friction demand. So I'll talk about friction supply first.
mhm,
So one of the issues that Dr. Flinch and Mr. Hine addressed are recommendations that Golder made in relation to microsurfacing in 2014 and shot blasting in 2019. With respect to microsurfacing, they have differing views because they disagree on the interpretation of the friction values and whether it's low or not. Mr. Hine's view is that microsurfacing was not needed, in light of the friction values, and certainly not justified for its costs, which would perhaps I believe be in the order of $1 million or so. So in his view, the return on that investment and considering a municipality's balancing of pros and cons, that's not there. An important point to note, though, is Dr. Flinch says that microsurfacing could have addressed a friction problem, but he actually doesn't go on to say when it should be done or whether or how to address microsurfacing in the context of other options which may have been available. And just the go forward, friction demand is, of course, something he agrees is another way of addressing skid resistance issues. With respect to shot blasting, again, Mr. Hine doesn't believe it's necessary, but in any event, Mr. Hine and Dr. Flinch agree that at the time of considering shot blasting, it was not necessary given that resurfacing was in the works. And shot blasting itself is a very temporary remedy in the range of months, with some uncertainty as to its effectiveness, which was raised by Mr. Hine, who's actually done it before.
so I had a little trouble understanding the evidence with respect to microsurfacing in 2014 in terms of what was intended. If I understand correctly, and please help me if I've got it wrong, Mr. Uzarovsky proposed microsurfacing not principally to address friction at all, but in the context of pavement prevention, as a pavement prevention tool for extending the life of the surface coat. And Mr. Moore was of the view that he didn't like microsurfacing for that purpose. He'd had some experience with it in the city, and it had been negative or uniformly negative, and therefore he wasn't accepting it. But this discussion was all in the context of treatment of the pavement surface as it existed at that time. Is that your understanding, or do you have a different understanding of that discussion back in 2014?
So I confess I may need to go back to some of the documents to confirm. I think it's on the right track, but if I can have the opportunity to come back.
Okay, so the follow-up, and the reason for asking the question was, I had trouble understanding Dr. Hine's evidence, whether he was actually talking about or commenting on the appropriateness of microsurfacing in that context in 2014, or simply as a means of increasing friction back in 2014, which he wouldn't have felt was necessary, or whether in fact he was talking about microsurfacing when it reappeared as a recommendation of Dr. Ruzarovsky later on, around about 2017. How do you understand Dr. Hines' evidence?
So Mr. Hines' opinion on microsurfacing was focused on whether the friction aspect
Right.
of the question.
As of 2014.
As of 2014, yes.
And he felt it wasn't appropriate from cost benefit analysis, given how he estimated the friction situation.
That's correct.
Right.
That's correct. That's his view.
Okay.
So now looking at friction demand, skid resistance from the friction demand side. Both Mr. Hine and Dr. Flinch agree that friction demand is affected by various factors like speed, curvature, ramps, human factors, and so on. Mr. Hine and Dr. Flinch were both asked about the 2015 SEMA report, which concluded that a combination of speed and wet surface conditions may be the primary contributory factors to wet road collisions. And it was also agreed by both the expert that there's not enough evidence to say, which one of speed or wet surface conditions is the primary contributor of those collisions. So in that case, again, it's accepted by both experts that a perfectly acceptable way to try and reduce the number of collisions or the severity of collisions is through countermeasures, such as reducing speeding. And why is that acceptable? As the experts have told us, reducing speeding lowers friction demand. It's the simple point that the faster you go, the more friction you need. The slower you go, the less friction you need. So it's not necessary for a municipality, for example, to immediately hire a road construction crew and bring out the large machinery to change or alter the pavement surface. Of course, that comes with significant costs, whether it be monetary or impacts on traffic. And it comes with some uncertainty about the effectiveness as well. And in Mr. Hines' experience, countermeasures such as signage or speed enforcement will have a substantially higher impact on collisions than incrementally increasing the friction on the pavement surface. And in his evidence, he warned us, he's warned that increasing friction does not necessarily reduce collision frequency. It may have no effect at all. So it's going back to the balancing aspect of really what to do. Mr. Hines' evidence on this point is not disputed, and I think it's important to keep in mind as you hear the submissions of my colleague, Ms. Contractor. I just have one final topic to talk about before I turn it over to her. So with friction values in mind and having regard to the role of friction, I just want to briefly address the topic that all experts address, which is ranking contributory factors to wet road collisions. And the four factors that were looked at from the legal memo is slipperiness, speed, curves, and proximity of ramps. With the exception of Mr. Brownlee, all of the experts effectively testified that to rank those factors, more analysis needs to be done, like accident reconstruction, or as Dr. Flinch says, more scientific evidence is necessary. So Mr. Brownlee concludes, though, that reduced road surface friction is the primary or the highest ranking contributory cause of overrepresentation of wet road crashes, and that the four factors can be ranked. Unfortunately, he's alone in that conclusion, and for that reason alone, I think the conclusions of all the other experts should be preferred. But moreover, as we've detailed in our closing submissions, his conclusion is not based on any overrepresentation analysis that he did in general, or specifically in the context of the Red Hill Valley Parkway, to actually substantiate his conclusion, nor is his view supported by the Highway Safety Manual, which we talked about, and is a manual that is based on it's quantitative, based on an abundance of quantitative data as to what the key causes of particular accidents are. So he's inconsistent with the experts. He doesn't do his own analysis, and he's not supported by the available authorities. So that is all I intended to make submissions on today, Mr. Commissioner, with respect to friction and road safety.
Thank you.
I did say I owed you with respect to the conversation between Mr. Moore and Dr. Guzarowski, so I will look into that.
Okay.
It is now 11:45. Would I be imposing if we ask for an early lunch due to scheduling issues?
I'm sorry, you have a scheduling issue?
Just on, I don't have a scheduling issue, but we're just trying to, obviously there's a couple others that will be making submissions, and is it possible to have an early lunch?
Ms. Contractor would prefer to defer. Is that what you're asking or saying?
In effect, yes.
Okay, I'll just look if do any of the other council have any concern about taking our break now and returning at 1 o'clock? I don't have the other council on my screen, but I'll assume the silence indicates no. In that case, then let's stand adjourned until 1 o'clock.
Thank you, Mr. Commissioner.
Okay.
Opening breakout rooms will resume at 1 o'clock.
Good afternoon, Mr. Commissioner. May I begin?
Yes, please do, Ms. Contractor.
So in my submissions this afternoon, I'm going to continue the theme of looking at the impact of the limited disclosure of the Tradewind report on the functionality of the Red Hill and the safety performance of the Red Hill. Next slide. And as you'll see, and the three categories that I'm going to be focused on with respect to the terms of reference are category 3, looking at the steps that the city has already taken and has been taken since 2010 to monitor, to maintain, and to improve the safety of the Red Hill. The category 4 terms of questions asks us to consider the impact of the non-disclosure or the limited disclosure of the Tradewind report on the safety performance on the Red Hill. And lastly, I'll speak to the steps taken after Mr. McGuire learns of the report in 2018. And mostly, so sorry, would you like me to slow down?
No, it's fine.
Okay. And the last category will largely be about the issue of interim measures and the dealings between legal services and public works. Thank you. So I'm going to start by touching very briefly on the various programs that the city had already put into place to improve the Red Hill. We've detailed those in our closing submissions, and so I don't want to spend too much time on that, but I do want to highlight a couple of them. Then I will look at the independent third-party safety reviews that the city had arranged for the Red Hill, and specifically we'll spend some time on the 2013 and the 2015 SEMA reports. And again, lastly, I'll take you through the evidence regarding the steps taken by the city to confirm that the Red Hill continued to operate safely in the latter half of 2018 after Mr. McGuire learns of, excuse me, learns of the 2014 draft Golder report and the Tradewind report. Next slide. Just to take a step back first, we've of course over the past 2 years learned a great deal about the city's public works department. It's a busy department, to be sure. It's got an important job. It provides essential services to the residents and visitors of Hamilton, including roads operation and maintenance and infrastructure rehab for over 7,000 lane kilometers for urban and rural roads, of which the Red Hill is about 7.5 kilometers. And of course, in addition to the roads work that Public Works is responsible for, there's infrastructure rehab, parks, open spaces, and a number of other matters and subject areas that you can see up on the screen. And so given these competing priorities, say, for example, between waste management, forestry, and water, it's really important that municipalities and the sections and divisions and really city staff members be mindful about how they allocate their resources and that they do so in an effective way. And I'll just stop here and highlight a quick example of this. And if I could get to the next slide, please. One of the ways the city staff can make a decision about how to effectively allocate resources when faced with competing priorities is, of course, to rely on the advice from their consultants with respect to, what really needs to be done versus what's optional. And of course, in her report, Ms. Baker, the public policy expert put forward by Commission Council, she provides some really helpful guidance on that. And her quote is up on the screen there, but essentially she notes that recommendations from consultants about things that the city must do versus things that are optional are so essential in ensuring that the city's time, its efforts, its resources are assigned to the right priorities. And I'm going to take you back to this a little bit more when we get to the 2013 NCMA reports, but I did want to highlight that point to you quickly here as well, because you know, Mr. Commissioner, it really does provide important context in assessing the decisions of city staff. Okay, so the next slide, please. So we know as well from our all of our education in the Public Works Department, we know that it's been restructured and reorganized quite a bit. And a lot of that is a result of recommendations from an external consultant core that has strived to make the department run more efficiently. One of the main divisions in that department, the Transportation Operation and Maintenance Group, that's the group that was responsible for the safety and maintenance of the Red Hill, you know, which included evaluating the existing traffic conditions. We're going to stay focused on that group for the majority of my submissions, and because, as I say, they were the ones that were putting in all the work to maintain and improve the Red Hill. The asset management section and the engineering services division, as you know, is responsible for the infrastructure, the durability of the roadway. That's a fairly clear line in the sand. But of course, as we know, there's some confusion about that when it comes to friction, and largely because friction in and of itself lays somewhere in the middle of those two things. Okay, so here are a few of the city programs and initiatives that I'd like to highlight for you. Again, this is not a comprehensive list, and we've included some additional materials in our closing submissions, but wanted to highlight a couple of things here for you. So the traffic safety status reports and annual collision reports are similar reports that provide traffic collision statistics and basically a breakdown of the collisions and identify some patterns that emerge from those collisions. The traffic safety status reports ran until 2010, I believe, and they included network screening data for the last few years before that. The annual collision reports began in 2017, and they both functioned as a way to have some transparency between the public and council and keep people up to date as to the work of these departments when it comes to the safety of the roads and the safety of the Red Hill in particular. Pardon me, I'm just gonna.
I just want to confirm, between 2010 and really the end of 2018, when the collision report was finalized, and I guess beginning of 2019 actually published, there were no published collision statistics, correct?
That's correct. And if we could go to slide 55, and that touches on that a little bit. And so you're right that the last traffic safety report included network screening information from 2005 to 2009. The 2007 annual collision report included network screening information for 2013 to 2017. So it goes all the way back to 2013, but you are correct in that it doesn't come out until 2017.
No, 2018.
Yes.
Right. My recollection is that there was a draft. The first draft was in the summer of 2018. Mr. Soldo wanted considerable changes to it. And it was approved in February of 2019.
So there is a 2000, I think the reference to the 2017 annual collision report, and I'll happy to double check this.
Yeah.
It contains the network screening
Yes.
list for 2013 to 17.
Right.
And it
The
was,
information itself wasn't actually published. Indeed,
that's right.
wasn't actually available to anyone until the summer of 2018.
That's right. I think it still may be called the 2007 annual collision report.
Yeah, of course. Yeah,
But you're
because
correct in
it's for the period that ends at the end of 2017.
That's right. Okay, so you're right in that there is a hiatus, and largely, as we understand from the evidence, because the director that was responsible for that program had moved on, and so there's some personnel issue. But I did want to note here that notwithstanding the hiatus on the network screening program, we know that staff were doing their own collision reviews of the Red Hill in 2013, in 2014, particularly with respect to wet weather collisions. And of course, in January 2018, the city engages SEMA to do a collision memo. Later that year, there's a roadside review along with a number of other SEMA studies through which a collision analysis is being completed. And then the January 2019 memo as well. So there's a number of folks that have their eyes on collision data for the Red Hill between 2014 and 2019 time period, notwithstanding the fact that the network screening program and the collision countermeasure program was not up and running at that time. Okay, oh boy. Just going back a couple of slides, I wanted to chat a bit more about the network screening and collision countermeasure program. So, Laird, if you could go to the next. Oh, you're already there. Perfect. So, the city's network screening program, and we've heard evidence on this, it uses a sophisticated methodology to carry out comprehensive review of the city's entire road network and to identify the locations at which collisions are overrepresented and that could most benefit from improvement in order to best allocate the use of the city's resources. And at the time, under the collision countermeasures program, there would be monthly meetings where the list identified by the network screening program were discussed. Specific segments of the road were provided to specific members of the group. And then there would be a presentation from that member identifying, what the issues might be on that roadway or segment of the roadway and ways to address it. And I wanted to provide an example about the Red Hill because it shows that this program worked exactly the way that it ought to have. So if we can go please to slide 54.
Can I just confirm?
Sure.
We are talking in terms of time frame of the period up to 2010. Is that correct?
That's correct.
Nothing past that.
So as I mentioned, the collision countermeasures program worked from 2007 from the start of the Red Hill 2007 to 2010. It did operate before 2007, I believe. And it went on a hiatus because of some personnel issues and then was resumed in 2017.
Mm-hmm. I'm just wondering if we have any evidence about its operation in 2018, for example, or 2019.
So I believe Mr. Soldo confirmed that it continues to be a program that the city is using.
Yeah. But in terms of specifics, in terms of what it's identified and whether that includes sections of the Red Hill Valley, I don't recall any evidence in that time frame as opposed to much earlier.
So I believe is your question, sir, whether there's evidence that the network screening program, once it was resumed, worked to address any issues then that may have been identified on the Red Hill through that list? Is that your question?
Essentially, yes.
Okay. So I think in part the chronology will play a bit of a will present a bit of a challenge, but as you'll recall, in his examination, in Mr. Solda's examination, he did a very comprehensive review of the annual collision report with Commission Council, and at that point went to the network screening list. So that would have been from 13 to 17, so all the years. And I can confirm this, although I'm fairly certain that there were no sections of the Red Hill main line that appeared, but that there were some sections of the Red Hill ramps that did appear. And at the time, as you'll recall, Mr. Soldo had just started at the city. There were discussions about resurfacing. The roadside assessment review had begun. And so I'm happy to go back and find some pinpoints, but I think my general response to that, sir.
Okay, we'll take a look. Okay.
The general response would be that the annual collision report, the 2017 one or the 2018 one, whatever you want to call it, but the one that's giving you the numbers from 13 to 17, to the extent that it identified segments of the Red Hill, those were addressed through the roadside assessment and the imminent paving.
Right. Yeah, I just looking at the first of your points here, the Mud Street off ramp or ramp 6, ramp number 64. That's back in 2010, I think, but I'm not.
It is, and we don't have to. It's in the closing submissions. We don't have to go through it. It just was an example of showing that program worked then, and for the reason I just shared with you, I think continues to work going forward as well.
Okay.
I'll just make a quick note on this point because it does become relevant a bit later on when we talk about the 2013 SEMA report. And so all I'll say about this is this ramp is ramp 6 as is identified in the 2013 SEMA report. And as a result of this collision countermeasure program, a number of countermeasures were implemented between 2010 and 2013, which included left-hand signs, curb warning signs, you'll see the list there up on the screen, speed advisory signs as well. And so that becomes relevant when considering whether ramp 6 needs further recommendations at the time of the 2013 SEMA report, and we'll chat about that then. And then the last program that I wanted to just touch on briefly is the Hamilton Strategic Road Safety Committee. It's composed of representatives from a number of stakeholder groups, including the Hamilton Police and different departments of public works, including traffic operations and engineering. And the objective really is to have regular meetings to find ways to reduce collisions on all roads, but specifically with respect to the Red Hill as well. And it was through their initiative, for example, that in 2016, the committee worked to have the Hamilton Police Services establish an aggressive driving enforcement campaign on the Red Hill. So just an example of some collaboration between city groups and external city groups as well.
Mhm.
All right. So those are the few kind of internal programs that I wanted to raise with you. I'd like to move now on to the external work that the city, arranged, particularly the 2013-2015 SEMA reports. So we've heard evidence a few times, I think, that there really is no road like the Red Hill in Hamilton. It's a high-speed parkway, and it's unlike the Link, which of course is quite linear. And so given the particularities of the Red Hill, the first thing that the city did right is it went out and sought consultation from an independent third-party expert to conduct the safety assessment. And there's a quote here from Martin White, who of course was then the manager of traffic operations and engineering. And he says, one of the things I'll say is that traffic staff, we're experts in local residential roadways, arterial roadways, but operating essentially a parkway halfway between an arterial road and a freeway or a highway, we didn't have a lot of experience with that. And I think it was prudent to hire a consultant who would have a lot of experience with that and who could assess those things from a much higher perspective and had more knowledge and expertise in that. And similarly, if we go to the next slide, please. Jeff Lupton, the director of energy, made similar comments noting the importance of engaging a consultant, an outside party that has an unbiased review of what needs to be done with the appropriate expertise. So again, this shows that with the traffic group particularly understood their own limitations here and appropriately sought out and relied on the independent expert advice in assessing the safety of the roadway. You can skip. Thank you. So before we jump into the nitty-gritties of the 2013 SEMA report and really take a look at, well, what steps did the city take and what steps didn't they take? In my view, it's going to be very important that we consider the context in which SEMA made their recommendations and the context in which city staff understood those recommendations. And specifically, there's, if we can skip the, thank you. Specifically, there's what I'm calling 4 foundational principles or factors, or however you want to call it. But before things we really need to look at in detail. I'm sorry, we've looked at that and provided the evidence for it in detail, so I'm not going to go too much in detail here. Because frankly, I think a lot of this stuff is common sense, but we did get a lot of evidence from folks from SEMA, from the city, about their expectations in working with consultants and the type of recommendations they expect. And so we provided that to you in the closing submissions, but I do want to touch on a few of these here. So first is that consultants ought to identify any actual or potential safety issues immediately. I don't think that's a controversial statement. Certainly it is consistent with the express agreement with SEMA. I think in their 2013 request for proposal, that language is found there. And certainly city staff and their evidence have also stated that, yes, of course, I'd expect the consultant to advise me of any actual or potential safety issues and not to wait for the report, but to let me know as soon as possible. And we can go to the next slide. I wonder if we could move, I'm not able to see the full PowerPoint screen, so I wonder if we could just move the talking. Yeah. Side. Thank you. Apologies, Mr. Commissioner. Yeah, that's better. Move it up. Yeah. And the next factor or principle, and it's certainly an important one, is that recommendations ought to be identified as mandatory or optional, right? And we heard from, again, Ms. Baker, from the SEMA witnesses and the city witnesses on the importance of distinguishing between recommendations that are mandatory or should be considered, and recommendations that may be helpful, but are ultimately discretionary and may not be required. And here we just have a quote from Mr. Malone, acknowledging that should be considered is used deliberately in the traffic transportation engineering world. It indicates that really an action should be done, and unless there's a really good reason not to, and otherwise could be done means that it's optional and not required. And what's important to note here is that not only are SEMA, the SEMA witnesses saying that this is what we do, this is how we use the language in our report, this is what it means, but we also have evidence from the city staff, including Mr. Cooper, Mr. Ferguson, Mr. White, Mr. Warren, and Mr. Lupton, all of whom, again, worked on the 2013 or 2015 SEMA report and confirmed that they had a similar understanding of those terms. And so when SEMA is saying you could do something, they are interpreting that as, I don't need to do this. I'll put it on the back burner and try my low-hanging fruit, so to speak, countermeasures first. And if I'm unsuccessful at that, then we'll try that in the future. And speaking of low-hanging fruit, the third factor here is recommendations need to have appropriate timelines and be prioritized to allow for a staged approach. And the staged approach, or the prioritization of countermeasures, it is really an important factor here, and it continues to be as we assess what staff did and didn't do in 2013 and 2015. And based on my understanding of Ms. Baker's evidence, it is actually a good way to make sure that you are making the best use of municipal resources and time. And so that's an important factor with certainty.
Could you help me out on this? I think that's at the level of generality at which you've pitched it, unimpeachable, but I read Ms. Baker's evidence to be that's appropriate responsibility of staff rather than the consultant.
And so, sorry, so are you, just so I understand your question, and your view is that Ms. Baker says that staff are responsible for prioritizing their countermeasures, right? And I don't disagree with you, and I think that's what we've seen, in fact, with the city staff. And I think what I'm attempting to say here is that recommendations from a consultant should have timelines to allow for this type of prioritization. And
yes,
where possible, of course, right?
Timelines in the sense of what it would take in order to implement something, yes. timelines in the sense that they incorporate the priorities of the staff. I thought that was something that Ms. Baker thought was inappropriate.
Give me 1 second. I'm just gonna go back to my Baker quote, make sure I have that right. So the quote that I had previously put up, I take it that that's not what you're referring to, though.
No, I think you'd really have to read the report more in its entirety, I think.
Right. So, and maybe you can give me a better sense. And I'm sorry, I'm not following of what your question is. Is it about the appropriateness of the staged approach?
No, but to give an example, if something is not, if the staff is of the view that a particular countermeasure is not budgeted for and therefore can't be done in the short term, let's say, it's for staff to say that, not for staff to advise the consultant and have the consultant, in effect, determine the proposed recommended timeline by reference to staff's view of the budgetary feasibility of something.
Right. And I think you might be referring to, I'm just trying to find it because I think I have a screenshot of it in one of my PowerPoints. Otherwise, yeah, why don't we go to slide 70? We're up ahead a little bit. And might be smaller than I was hoping, but this is the page from the 2013 SEMA report where SEMA states the city has indicated that with respect to a select number of countermeasures, a staged approach to implementation will be undertaken. Is that what you're referring to, Sarah?
I'm not sure that I was specifically referring to that.
Okay.
No. Okay, I've given you the question. Why don't I just leave it there? And I don't want to interrupt your presentation.
It's fine. Okay, so if we could perhaps go to the, let's see here. Slide 64. So we've touched on 3 of the 4, what I've called foundational principles, which really stem from the expectations that staff have for their consultants and consultants' understanding of what they are required or may be asked to do. And the last one there, no such thing as a safe road. You can only make a road safer. That's come to us from a number of different sources, but that particular line was from Mr. Malone in his, I think his June 1st examination. And I'm happy to find the site for you if you'd like, but I think this is an important point because it reminds us that safety is not a binary, that a road can always be made more safe. And so to take you back to, the city worker that is making decisions in the face of competing priorities, and it's looking at the information it's obtaining from its consultant about what's necessary and what's optional, and timelines that allow for a staged approach, and considering that a road can always be more safer. I think that there's a lot of discretion left with staff about when and how to implement some of these things, depending on the guidance that they get from their consultant. And as we go through the specific recommendations in the 2013-2015 report, we'll see that manifest a bit more clearly. Okay. Okay, so the 2013 SEMA report. It, of course, was not a review of the entire roadway, but a portion of it. The conclusion, the overall conclusion was that they did not identify any urgent or significant safety issues in that study area. But they did identify countermeasures that would improve the safety performance of some of the other study areas, and identified segments in the main line and the ramps that could benefit from improvement. I want to start by looking at the collision analysis in the, sorry. So we can go one step back. Great, thank you. And so continuing with the key findings. So as I said, they conclude that the study area was performing well overall. But they also conclude that there are some segments of the Red Hill that have a higher proportion of certain collision traits, such as wet weather or non-daylight conditions. Excuse me. But as we note in our written submissions, there are some significant limitations to this analysis that would undermine that conclusion. And Mr. Malone on his examination agreed with many of those limitations. And so I'd like to take you through that now, because the collision analysis is essential to their finding that there was a high proportion of wet weather collision, which of course is which underpins the recommendations ultimately made in the report. So we know that SEMA did two types of collision analysis. We can go to the next one, please. Thanks. Without going into too much detail about this one, the ISATE tool, essentially it's an analytical model that is calibrated across a number of other facilities, and which allows it to assess the expected number of collisions on segments and compared to the observed numbers to try to have some sort of apples to apples comparison between different facilities. The SEMA report itself notes that there are significant limitations to using this tool on the Red Hill because the ISATE was not calibrated for Hamilton roads. And the report goes on to state that calibration is important because it ensures that the evaluation results are meaningful and accurate. And so what does this mean? It means that we can't use this tool to compare it to other facilities that might be similar to the Red Hill, but we may be able to use it to compare it to parts of the Red Hill against each other. And on examination, Mr. Malone agreed that there are limitations to this approach as well, because comparing segments of the study area of the Red Hill against others when assessing collisions, you're essentially again, doing a bit of an apples to oranges comparisons, because segments with different characteristics are going to have different expectation of collisions. So based on the ISATE, and that's not going to tell us whether or not a segment of the Red Hill, or certainly the entire Red Hill, or the study area in this case, I should say, has a high proportion of wet weather conditions or non-daylight collisions. We can go back to the other one. And the second type of collision analysis that SEMA performed in the 2013 SEMA report was simply to look at the proportion of wet weather collisions or non-daylight conditions, non-daylight collisions, and just to compare those to the proportion to the municipal and provincial average. And you know, I think we can all see the flaw in that comparison. And oh, I see Heather has come on the screen. I want to make sure she's not. No, okay.
So sorry for the interruption.
Oh no, that's fine. Yeah, so I mean, I think we can all see why that would not be an adequate comparison, but I wanted to show you one example that I do think really brings this home. And if we could go to the next page, please. Thank you. During his examination, sorry. Mr. Malone was asked to compare the proportion of wet weather collisions in the study area to a similar location 400 series as noted in SEMA's PowerPoint delivered to the city on June 6th as part of one of the progress meetings. So that's the table you're seeing on your left-hand side. And you'll see a similar location 400 series is at the very top. Study area is in the middle and ramp 6 is at the bottom. Commission Council notes that the proportion of wet weather collisions on the similar location 400 series is about 20%, which is higher than the proportion of wet weather collisions in the study area. And Council asked Mr. Malone for his views based on the comparison he saw in 2013. And in response, and a part of Mr. Malone's quote is provided on the right-hand side of the screen. I thought it was helpful. But in his response, Mr. Malone cautioned against concluding that the Red Hill was, quote, worse because the 400 series facilities have a lower percentage of wet weather collisions. And in fact, the quote is in here, but he goes on to say, and that is excerpted in our closing submissions. He goes on to say that the proportion of wet weather and SMV single motor vehicle collisions did not cause him any concern, noting that roadways or ramps with horizontal alignment or tight curves, you're just going to have a higher proportion of wet road collisions. And that's just how it goes, unfortunately, with those characteristics. And he also notes that it's fairly common for single motor vehicle collisions to be the primary type and for the proportion to be that high on a roadway such as the Red Hill. And again, I think, Mr. Commissioner, that Mr. Malone's evidence on this issue is quite significant. It really speaks to how city staff would have understood the safety performance of the study area, including the incidence of wet weather as well as the incidence of single motor vehicle collisions, and the urgency with which any countermeasure or investigations would need to be conducted. And indeed, during their examinations, Mr. Martin White and Mr. Ferguson, again, the manager and superintendent of traffic at the time, gave similar evidence regarding their understanding of the limitations to SEMA's collision analysis, particularly with respect to the notion that there was a high number of wet weather collisions in the study area, when what you're comparing to is oranges, not other apples. All right, we can go to the next.
And what is the currency of the data that was used for the SEMA 2013 study?
What was the currency of the data?
Yes, how current was it?
And that is a good question. And let me find that for you in one moment. I don't have that at the top of my head, although I ought to.
Mhm. Okay.
I expect the last 5 years, but any of my colleagues are able to help me out, feel free to. So it's a 5-year period from October 10th, 2008 to October 9th, 2013. And that's at page 4 of the 2013 SEMA report, if that's useful to you, sir.
Okay.
Okay. And so we're back at the staged approach. And in terms of the way that the city and particularly the folks in traffic implemented the recommendations coming out of the 2013 SEMA report. And so what I propose to do is quickly take you through the work that was completed, and then focus on the 2 optional items, recommendations that were not implemented, being friction testing and the high surface friction recommendation for ramp 6. And so here, consistent with that staged approach, the evidence indicates that the city implemented the following countermeasures within the timeframes recommended by SEMA, which again were between 0 and 5. And so you have it up on your screen as well. And they included slippery when wet signs, oversized chevrons, left and right hand signs, curve and warning signs, and specific signs were installed and upgraded to high intense sheeting for ramp 6. Eventually, installing recessed reflective markers were also put in between Greenhill and Dartnell Road. I'll just make a note here about the slippery when wet signs. I know that there was a lot of interest about when and whether they were done. And we know, apart from the emails and reports to council that show the signs were implemented, we know as well from the 2015 SEMA report, when they're doing their signs review, that they observed the slippery when wet signs that were previously recommended installed. So I'll just add that for you as well. Okay, so want to chat now about the two recommendations that in our view were reasonably not implemented. Again, keeping in mind the nature of the recommendation, the should, the could, the timeline, as well as heavens, sorry, my computer's trying to make me update. Giving me 60 minutes. Hopefully that'll be all we need. Yeah, so when you're looking at the nature of the recommendation, you know, the fact that the friction testing is a could consider, not a should consider, the fact that it's a 0 to 5 year range, and you know, they're not able to even, SEMA is not even able to provide them with a cost benefit analysis to it. I think all of that fairly, as you've heard from the city witnesses, all of that is interpreted by them to mean that this is not something that needs to be prioritized, and based on the guidance they're getting from their consultants.
So that's a good example. Why is the consultant even wading into this? Isn't that really something for the city staff to decide? And a little bit more directly, one suspects that maybe the city staff is looking for cover.
So,
and they should be straightforward with the council as to whether or not they think this is useful at all.
So again, you're talking about the staged approach.
No, I'm talking about considering the friction testing as a very good example of, yes, of the staged approach.
I see. Well, I mean, I think that there's a couple of reasons here. And one, I see the benefit to the city of getting sign off by the consultant. And, you know, they've made a bunch of recommendations, and some of them are all at the kind of same caliber, if you will. They're all could consider, they're all 0 to 5. And so now the city says, okay, it looks like we have some room to play here. Here's how we think we're going to do it. And they present it to their consultant to say, is this okay? Do you agree with this? Is there a different way to do that? And the evidence that we've heard from both the consultants as well as the city staff is that oftentimes this is a collaborative process, right? The consultants don't know what's feasible. They don't necessarily know maybe some of the political entanglements, and vice versa. City staff may not have the best technical sense in some fields to know what's the best order to do this. We're thinking of doing it that way. Is that going to cause a problem? And if the consultants do agree with that, I think that, yeah, that probably adds a greater level of comfort for the city to say, okay, well, we've not only have we decided this because we think it will be efficient, but we've also just double checked it with our consultant and make sure that they're okay with it. And that's the way that I look at it, as opposed to, you know, pushing the consultants into agreeing to something that they want to do. And we know for sure, we've heard from Mr. Malone particularly, that you know, if it's not something SEMA agreed with, they wouldn't agree to it. We've seen examples from them in the context of the 2015 staff report, and you'll recall that there was a draft staff report that Mr. Ferguson sends to SEMA, where under a different definition of medium term, friction testing is put in as medium term, whereas for SEMA it was a short term, and they refused. That, you know, there was a comment that said, I disagree with this, let's chat, and ultimately SEMA did not agree with that recommendation. So I think the fact that the consultants themselves are obviously have the ability and obligation to refuse to agree to something if they don't think that it's necessary or safe or whatever it may be. But I don't see the harm of the city getting a second check from their consultant to say, this is how we're going to execute it. Is there a better way? Would that work? What are your thoughts? Because it is a collaborative process.
Okay.
Sorry, just give me 1 second. Florida, could you put up 72? So, I'm sorry? We lost what? Oh, we're on 72, sorry. Okay. So we were about to speak more specifically about the friction testing recommendation in 2014 from the 2013 SEMA report, I should say. And again, you know, the nature of the recommendation and it being optional and there being no cost benefit analysis, and there really being no understanding of friction, or no, it's not a common thing that's done. And in our view, it's not unreasonable for the city to try some of the other recommendations that SEMA has made, many of which also address wet weather collisions, including slippery when wet signs, and give it the appropriate amount of time to observe its efficacy. And then if that doesn't work, try your optional countermeasures, in this case, friction testing. But you know, in 2013, in our view, it's not a unreasonable way to go to start with the low-hanging fruit, if you will, and monitor its effectiveness. And Mr. Ferguson, in his testimony, provided some insight on this as well, and that quote is before you as well. So he first talks about his understanding of the friction testing recommendation, again noting that consultants will clearly identify things that are necessary and ones that are optional and could be implemented as a follow-up after the low-hanging fruit. Excuse me. And after investigations are completed. He says, again, in our industry, we look at the wording that's associated with those reports. So we're going back to the railway stake. This is an example he gave about working at a railroad industry, where it's very clear, it's very upfront. They provide additional information that says, the municipality, you can look at these items. It's not a requirement. You could do that if you want to supplement the location, but it's not an actual requirement. When you go back and you use that as a comparison to here, this is in reference to the friction report, the friction testing recommendation. A number of the items are identified as could or as a follow-up. If your pre-countermeasure, if you find that they are not addressing the situation, then upgrade to these new installations or these additional countermeasures. Have I answered your questions on that point, Mr. Commissioner?
I think you've addressed from your perspective, yes.
Okay, and I'll touch briefly the ramp 6 recommendation, which again was not was an optional recommendation that was not implemented, and there's compelling evidence about why that wasn't taken, and again kind of goes back to this staged approach, and so the evidence that I took you to earlier about a countermeasures program from 2010 through which a ramp 6 was identified as a potential area where there was an overrepresentation of collisions. And as a result of that, there was a number of work that was done. And in light of that, and in light of the fact that they didn't have sufficient time from when the work was installed to the date of the SEMA review to really assess the efficacy of the work, the decision was made just to hold off, see how the work that they've already put in place had fared before looking at additional measures. And Mr. Appleby from SEMA was asked about that, and he stated that the signage improvements implemented by the city were reasonable, and that SEMA's additional countermeasures were just an option to augment the work that the city had already completed.
Mhm.
Okay. I know we spent a lot of time in the inquiry itself on the 2013 SEMA report. There's nothing else that I intend to take you to, but I'm happy to answer any questions on that report specifically that I haven't addressed for you.
Well, you can address the propriety of someone calling up the consultant and saying, remove from the report the principal focus without that being explained to the city council who had originally requested the report. And I'm going back now to the Baker evidence. That seems to me to be the principal significance of that.
So you're speaking to the illumination
Correct.
Scope issue, and I understand. So as I recall, the evidence on that is a bit murky, and it was clear that illumination was in scope, and that was provided to SEMA, and as of one of the last progress meetings that they had before a draft was provided to the city, that continued to be there. And Mr. Appleby had you recall the exchange Mr. Appleby had with Mr. Malone, and where I think that's where the first hand grenade comment had come up. And he had asked Mr. Appleby whether, in his view, full illumination was still in scope. And at that point, he confirmed that no one at the city had told him otherwise. Mr. Moore's evidence on that is, as I recall, that he didn't have standing. He wasn't able to tell Brian Malone what is in and what's not in a report, but that he may have had a discussion with him, as he had with many others, about his understanding of the limitations, the environmental limitations that would preclude the environmental process. And I believe Mr. Malone's evidence on that is that he understood from Mr. Moore that he was telling him that lighting should be off the table. So I'm not, I can only present the evidence on that as I understand it, and I'm not suggesting, I think the evidence is a little bit unclear for sure, but it is important to note that there's nobody who was actually involved with that process stated that illumination was not out of scope. Mr. Moore did not have that authority and says that all he did was provide the information. But it's also important to note that the city had the proper processes in place to make sure that this matter came back on the OBL item, and which would allow staff to continue to work towards investigating.
Well, I think it came, to be fair, I think it came back on the OBL item because the council said, well, thank you very much for this report, but it doesn't do what we asked you to do, so go back and do it.
The wording of that 2013 motion was not restricted to lighting. It certainly was as you say, a key portion of it, but it was to improve visibility, signage, and a number of other factors. And I think in the meeting that was had between Councillor Collins at the time, who I believe made the request for the motion, and Mr. Ferguson and Mr. Martin ahead of the PWC, which I understand now with the city's new policies coming in, that type of sharing of information would be frowned upon or not permissible. But I think that was, again, an opportunity to make sure that the motion, the report was responsive to the motion. And frankly, it took a similar kind of staged approach, right? Put in the measures to increase visibility, try some of this signage work, and then put it back on the OBL. If it's working, great. If not, let's take the next step.
Okay.
Okay. So I'm going to move on to the 2015 SEMA report. And before we get to the report itself, excuse me, I'll note that the documents show that the traffic group was doing some monitoring of the collisions on the Red Hill in 2013. And again in 2014, and by the end of 2014, had determined that a review of the entire Red Hill would be prudent. And subsequently, SEMA was engaged to do a detailed safety review of the entire Red Hill in the spring of 2015. And I think one of the key issues, of course, that I'm going to focus on coming out of the 2015 report is SEMA's conclusion that a combination of high speeds and wet surface may be the primary contributing factors to collisions on the Red Hill, and particularly where small radius horizontal curves are present. Sorry, Mr. Commissioner, I can't tell if you're writing or you're gone.
Oh, yeah,
there
no, I'm listening. Go ahead.
you go.
I'm doing both,
right.
this contractor.
Okay, so that, I think, one of the key issues coming out of this report, and certainly the inquiry has received a significant amount of evidence on that point. And the city, for the reasons that I'll go through, submits that, again, we acted in a reasonable way. And when you consider, again, the staged approach, the best information available at the time, and the expert evidence from Dr. Flinch and Mr. Hine, and lastly, that additional friction testing or additional friction information would not have resulted in an alternative course of action, as was subsequently confirmed by SEMA. So I'm going to go through each of those with you. And of course, if you have any questions, let me know. So following SEMA's conclusion that a combination of wet surface and speeding may have been contributing to collisions on the Red Hill, the city took immediate steps to combat high speeds. And again, that's the traffic group that's largely running with that. And at the same time, the engineering services group by April of 2016 had begun to consider pavement rehab and resurfacing. And I'll just focus a moment on the work that the city did to immediately combat excessive speeding that they observed on the Red Hill following SEMA's report. And for example, city staff within traffic operations worked with Hamilton Police Services to implement a comprehensive speed enforcement. You'll recall that SEMA had found that 70% of the vehicles on the Red Hill were traveling up to 10 kilometers above the speed limit, with an average of 500 vehicles traveling over 140 kilometers a day. The enforcement campaign included regular patrolling on the Red Hill and the Link, during which significant speeding violations were observed. For example, I think they issued rather 16,000 violations within the first 4 months. In addition to enforcement, and of course, oversized speed limit signs and slippery when wet signs were installed. And the city was also investigating the implementation of variable speed message boards and QN warning systems, and had engaged SEMA to prepare and develop a plan along those lines as well. When Mr. Ferguson was asked about why the city was focused more on speed as opposed to the wet surface side of things in that combination conclusion that SEMA made. And he said once again that the practice is when you're looking at competing priorities and limited resources, you're looking for the easy wins or the low-hanging fruit. Now, that doesn't mean that the mechanisms that you're employing aren't going to be effective, but rather that they are faster, easier to implement, and more cost efficient. Mr. Ferguson further noted that based on industry standards, it takes about 3 to 5 years to observe the impact of this type of initial countermeasure on collisions. And so he wasn't expecting a significant decrease in collisions overnight, certainly. And so while the traffic group took immediate steps to curb the excessive speeding, city staff in the engineering services group took steps to address the pavement rehab needs of the Red Hill and the link, and with the general objective of extending the pavement surface life, increasing surface levels, and addressing cracking and improving skid resistance. And in describing the purpose of the resurfacing at the time, Mr. Moore confirmed that although the rehab or resurfacing of the Red Hill was not prompted by concerns that friction on the Red Hill was deficient, there was an understanding, of course, that new rehab or resurfacing would naturally increase skid resistance. Mr. Andoga made similar comments when he was examined that the rehab was not directly related to a concern about the friction values, but of course there was an understanding that new pavement would result in better skid resistance levels. I'm going to talk a little bit more, Mr. Commissioner, about why the city's focus on combating excessive speeding was a reasonable pursuit in the circumstances at the time. And, Mr. Ferguson, for example, in his evidence indicated that, based on his training and experience and expertise, he understood that there are a number of contributing factors to any one collision, and primary, it tended to be driver behavior, and that was particularly the case in wet weather conditions. When asked if his focus on driver behavior would have changed if he was advised that in their report, Tradman recommended further investigation of the friction values of the Red Hill. Mr. Ferguson confirmed that, in the absence of a specific recommendation, i.e. pass, fail, thumbs up, thumbs down, for him, it would have been prudent to continue to minimize excessive speeding observed on the Red Hill. He further noted that the countermeasures that SEMA had implemented assumed to some extent that there was low friction values. So that included the slippery when wet signs and other signage. And so all of that had been put into place, and there was a targeted speed enforcement campaign as well, while engineering services in the background was looking at rehab.
I think the real question for
Please.
me is to ask what would they have done if they had all the information that Mr. Soldo had when he put it together in 2018. And that's not just the friction numbers, which got out of the trade wind report, but the SEMA's analysis of the collision history and the correct design speed, which Mr. Moore chose not to correct in the 2015 SEMA report. All of that information was actually available in 2015. And the question is, what would SEMA have done if it had had that information? Now, we know Mr. Soldo would immediately have reduced the traffic, the posted speed. So it's not so much that the focus on speed is wrong, is that perhaps they failed to do a more comprehensive report with further information, and perhaps failed to recommend as vigorous a response as they would have if they'd had that information. And I bear in mind that even SEMA in 2019, although they called it a slight modification, recommended more aggressive
Enforcement. That's right.
So it's not that you pick apart one particular piece. Is, from my perspective, I try to understand, given that all of that information really was available in 2015, what properly should have been done as part of the SEMA report, SEMA review, and what, if any, different recommendations might have come out of that.
So I take your question, sir, and I want to, I'm just trying to find the right reference, because you asked Mr. Malone that question. I don't know if you recall that. There were many days of the hearing, but you asked Mr. Malone that question precisely. And if you bear with me, and so we know that Mr. Malone confirmed that friction testing results would not have changed the countermeasures recommended in the 2015 SEMA report. And partially because SEMA had already intended to deal with any potential low friction issues, such that further friction results would not have warranted additional countermeasures. So similar to what Mr. Ferguson had said. And then in the February 4th memo, he concludes that even if he had a copy of the draft Golder and the Tradewind report, he would not have implemented any additional countermeasures in the 15 or 18. When examined on this, I just want to find the right. Pardon me, I'm going to just turn to my trusted marked up transcript. So when asked about whether he would have, he being Mr. Malone, would have changed the way that SEMA approached the assessment of friction as a contributing factor to collisions, if SEMA had the Tradewind and Golder report. So the question is, you would not have changed. He says, yes, I think that's right. And he goes on to state, and the problem with the Tradewind results is that they indicate, in my interpretation, friction levels that are in excess of the values that are utilized in road design. So theoretically, that should mean that friction is not an issue because the friction levels are provided. We have a preponderance of, he goes on to say, we have a preponderance of wet road crashes. I don't think it would be a smoking gun of confirmation that pavement surface was the key factor and problem in the resulting consequence of these collisions. And the smoking gun there he's referring to is the Tradewind report. He's saying that it's not the smoking gun. But you go on to ask, if, I know there was an objection here. So let me just go past that. You phrase the question in this term. If I understand the question correctly, bear in mind that in 2015, SEMA was not provided with the right design speed for the road, and it wasn't provided with the Tradewind report. Had it had those, effectively the memo should respond to both. And had Mr. Malone had both of those, would the answer or the recommendations been any different? And Mr. Malone responds and says, so to clarify, and spoiler alert, he's going to say that it won't make a difference, but it's a bit of a long answer. And he says, so to clarify, if the design speed is different, then the friction threshold value that I would be comparing to from the geometric design guide also moves. They move in conjunction with each other. And in preparation for this testimony, I had a closer look at the Tradewind report, which I would have done at the time, presumably. It consists of a range of data points. I think that there's something like 280 individual numbers that are provided through the run through the roadway. I took a closer look and I see only a change of one data point that would move in relation to a revised threshold if the design speed difference is nil. So it's not irrelevant, but it's not overly relevant. And my conclusion today, and again, it's in hindsight, is that I still don't think it would change our recommendation. I think it's a valid question to ask. And obviously in hindsight, we would have preferred to have it all, but I don't think it changes anything because the change between the two design speeds and the corresponding change between the friction levels provided in the design guidance is extremely small, only data point, one data point out of 280, sorry.
Oh.
Eyesight.
On the other hand, and just to fill in the evidence, that's Mr. Malone's evidence.
Yes.
He's in one might observe, a somewhat difficult situation. Even on his own evidence, they would have recommended more aggressive approach to speed enforcement. Correct? That's
right.
So his answer isn't exactly complete, but the experts, and on this point, there really wasn't much disagreement, had a different view of what they would have done had they been in SEMA's position in 2015.
So I'm glad you brought up the experts, because I actually think both Dr. Flinch and Mr. Hine agree on a really crucial point, which is where you have a circumstance where the demand for friction exceeds what is available. And Mr. Chen cross-examined Dr. Flinch on this point, and I believe we have an excerpt in our closing submissions, but it essentially, Dr. Flinch agrees that where friction is exceeded what's available, and one way to reduce the severity of collisions or avoid collisions altogether is, of course, to increase the friction value. The other way that you can go is to decrease the demand for friction.
Mm-hmm.
And Dr. Flinch agreed that it would, in the same way, reduce the severity of collisions or avoid them altogether. And I think that is an extremely important point, and particularly given what both experts agree on about the cause of collisions, right? Both agree that friction is seldom the cause of collisions, but when there are other factors, it can contribute to collisions. So is it reasonable then to, where friction is unlikely the cause of the collision, where friction demand is being exceeded by what's available, to take steps to decrease that demand through speeding, for example, through speed enforcement, as opposed to increasing friction, which is far more costly, and it's unclear whether or not increasing friction would actually reduce collisions.
Okay. Mhm.
And I not to be repetitive, but I do think that the fact that both experts agree on this, it's the evidence is unchallenged. It's when you're in that situation, there's two ways to proceed. And you know, Brian Malone made a really excellent point, at something. He made many excellent points, but he at one point, I can't find the quote, but said, you know, our understanding of friction in the role of collisions in 2013, 2015 really wasn't that great. And we've seen that from a number of traffic engineers, safety professionals who don't have any training or expertise. And I expect that's rapidly changing if it hasn't already. But I think, you know, this is an inquiry, and so looking at hindsight is still important. We want to know, you know, roads can always be safer, we can always be better, and of course the city is interested in that. But in terms of assessing the reasonableness of particularly city staff's decisions about pursuing speeding versus trying to increase friction, and you know, again, in our respectful submission, particularly given what the experts tell us now, that trying to reduce speeding would have been or was an appropriate way to proceed. And 3 years after, around 3 years after that, the roadside safety assessment is completed. I don't know whether that's in the roadside or one of the other studies, but we know that the percentage of wet weather collisions gets higher, right? And at that point, we have the resurfacing. So in a way, the staged approach, if you will, worked exactly the way that, you know, it could have. And there were two options. One seemed likely. I'm sorry?
I don't think this is about increasing the friction. I mean, and I'll only ask this last question and then let you get on, because I'm mindful of timing. But isn't it at least conceivable that with fuller information, SEMA would have adopted, or at least somebody in SEMA's position should have adopted, the approach that the city's own director adopted in 2018, which is drop the speed. At least conduct a full speed assessment. And one of those things, that's not so much related to friction, although friction becomes a component, as we say all the time.
Yeah.
It's the fact that that SEMA was misled as to what the design criteria were.
Right. And if I'm understanding your question correctly, sir, is it whether the speed study that was done, whether it should have been done earlier, and whether SEMA should have concluded that the speed ought not to be or should be reduced?
Well, I'm saying, I'm trying to assess what a reasonable consultant would have done in 2015 if the city had provided them full information. Bearing in mind that when that full information was available in 2018, the city's own director of transportation operations recommended, among other things, a reduction in the speed limit.
We're in a bit of a unique position here because we have the answer to both of those things. And we know what SEMA would have done because they've told us exactly that. They told us, other than, and you're right, that correction of slightly more aggressive enforcement, they would not have recommended anything else. And you'll recall that there were two versions of that February 4th memo from SEMA. And initially, Mr. Malone, excuse me, wished to include paragraphs where he advocated for maintaining the speed limit, while acknowledging Mr. Soldo's point, but ultimately I think, and I could be mistaken, but I thought that it was because of the speed differentials that he had some concerns about. Of course, ultimately the speed was reduced, but Mr. Malone, even after knowing everything in February of 2019, continued to maintain the speed limit at the time.
Okay, I don't want to slow this down anymore.
Sure. Okay.
Mr. Commissioner, I apologize for popping in. I just wanted to be your guardrails on time. It's 2:35 and we've been going for about an hour and close to 40 minutes. I just wanted to note that Dufferin is also going to be making submissions today, and we have not yet taken our afternoon break. So I just wanted to give you a sense after the spirited discussion between you and Ms.
Yes.
Contractor.
Okay, thank you.
Sorry about that.
Ms. Contractor, if we went to 2:45 and then we took a bit of a break to allow you and whoever else is speaking to organize their time, would that be reasonable?
Sorry, sir. So you're suggesting that we continue to 2:45 and then take a break?
Correct.
I can certainly finish in 5 minutes if that's what you're asking.
Yeah, that would be good.
Okay. Okay. So what I'll do is give you a few references to the part of the written submissions that I'm about to speak to, because I do think that this is an important issue. They're all important issues, but I do think that this is one. The period of time after Mr. McGuire found the Tradewin report, frankly, whether it's August 2018 or September, regardless, within that period of time, and let's say January 30th, 2019, I understand that there's a question about whether and who was responsible for considering whether any interim measures were necessary for the roadway. And in addition to that, whether legal services played a role in that. So I'm going to give you a very high level submission on that point. I would give you the following references in our closing submissions at page 74 to 87. And essentially, our submission on this is oh, sorry, I'm in the wrong spot. Is three, maybe fourfold. Now I'm making it up as I go. So first, the evidence is very clear that public works staff, and particularly Mr. Soldo, who you'll recall by this point had joined the city as the Director of Transportation Operation, the group that's responsible for the maintenance and safety of the road. He had reviewed the trade-in report and the draft Golder report around October of 2018, I believe. I don't have the exact date in front of me. But he was very clear in his evidence that he did not have any immediate safety concerns for the roadway. And that was in part based on the collision data that was found in the annual 2017 collision report. And again, you'll recall that that went from 2013 to 2017. Some of the things that Mr. Soldo had observed was, yes, when you look at those pie charts where, shows high wet weather on the Red Hill, low wet weather on the link, what one can, a layperson can take from that there is a big wet weather issue, and maybe it is related to friction. And he provided us with a more of a holistic assessment of all of these collision factors. So for example, he pointed to the fact that the Red Hill has a lower fatal and non-fatal injury percentage than the link. And from a Vision Zero perspective, which again looks at not the number of collisions, but the seriousness of injury collisions, that the Red Hill could be seen as performing better than the link in that case. He also looked at the excessive number of speeding on the Red Hill when compared to the link. And he goes through a number of these factors to say, here's why I thought that the road was safe. And then he talks about, or his evidence provides us with his explanation as to why the trade-in report did not change that conclusion. And there were 3 or 4 reasons for that. One was simply the nature of the recommendations, right? These guys are consultants, engineers. They've been reading these reports for a long time. Possible remedial work is not a recommendation that many of these see as a significant safety issue. And of course, Mr. Soldo had become aware of all of the work that was done since 2014. There were a number of SEMA reviews and work that the city had done internally as well. And he also understood that the resurfacing was imminent. And so if there's anything that needed to be done with the pavement, that was being taken care of. Mr. McKinnon, who was the GM of Public Works, and Mr. McGuire were less involved in the assessment of the safety, but they had similar views that they didn't think anything imminent needed to be done. And from Mr. McGuire's perspective, given it was the winter time, he didn't think that it was possible to do anything to the pavement. The 3 of them were also very clear in their evidence that at no point did they need to speak with anybody at SEMA to confirm their views about whether interim safety measures were necessary.
Mm-hmm.
And that's important because there is a narrative that legal services and perhaps particularly Miss Audie engaged Mr. Bogosian, the external counsel, in order to obtain advice from SEMA about interim measures on the Red Hill and to do it in a privileged way. Now, it is unfortunate that the language of the retainer in the email says something very similar to that. However, Ms. Audie has been clear that, of course, there is some overlap between those 2 measures, but that her area of expertise was to look at liability and to look at mitigation. And when you actually look at the report, not the preamble, but David Bogosian's actual report, the section is titled mitigation measures, and that's what he focuses on. When Ms. Audie was asked whether it would have been prudent to coordinate contact between SEMA and the Public Works team. She was clear again in her evidence that it could have been, but nobody from Public Works came to her to say, we need to talk to Brian. And Mr. McKinnon added to that to say that if anyone from his team came to him and said, anyone from legal was stopping me from trying to get to who I needed to talk to, particularly about roadside safety, that there's no way that would have happened. So I do think that this is a really important point. And we have two separate groups doing two things that have some overlap. But what is important to note that Mr. Solo satisfied himself. He's an engineer and is a celebrated traffic professional engineer, is in all kinds of committees that I don't have in front of me, but again, it's in our closings. And he was able to satisfy himself and advise Mr. McGuire and Mr. McKinnon of that as well. So although there are a few emails between Mr. McGuire and Justice McNeil, who was then the city solicitor, where Mr. McGuire is asking to speak with SEMA, is asking to have, I think at one point he says, a confidential conversation with SEMA. But both Mr. McGuire and Justice McNeil is clear in their evidence that they did not understand that Mr. McGuire was trying to talk to SEMA for anything related to the safety of the roadway. I believe his evidence on that point was he was trying to understand whether the scope of the budget, whether there would be additional items added to the scope of the roadside review such that it would impact his budget. So I'm 2 minutes over, and I'm sure I've rambled quite a bit, but if there's any questions, I'm happy to answer them. Otherwise, I'll pass it on to my colleague.
Okay. Let's take a 15-minute break. We'll return. Just a little past, but we'll return at 3 o'clock.
Thank you.
Okay.
is
Okay, are we live now, Mr. Registrar?
We are, Mr. Commissioner, yes.
Okay. So, Ms. Contractor, I have a few questions before we pass on to the next person. One of the central questions I have to address is what, if any, explanation one can give for the fact that Mr. Moore never provided the trade wind report to anyone internal to the city. He seems to have immediately flipped the summary information that he received by way of an email from Mr. Uzarovsky to Mr. Dzeko, but no one in the city ever got it. The MTO and Golder have given me their explanation. I wonder if you'd care to comment either on their explanation or how you put the various factors together that explain the non-disclosure.
Thank you, Mr. Commissioner. I'm happy to speak to that. I can take a look at my friend's submissions a bit closer and provide you with a follow-up response if necessary. But my initial response is that the non-disclosure would not have had any significant impact on the work that would have been done on the Red Hill. And we know that.
Let me just ask, is that your explanation for why Mr. Moore didn't do it?
Oh, I see. No, that
I'm really asking why Mr. Moore never disclosed this internally.
I see. As I understand Mr. Moore's evidence on this, and it's been consistent throughout, which is that he didn't have any questions about the data, the friction testing data, but he had questions about the Tradewind report, the use of the UK standard, and Dr. Yuzarowski's claim that although these numbers are higher than 2007, it's not an exact quote, but something along those lines in the draft 2014 report. Although it's higher, they're still relatively low. And Mr. Moore has been really consistent in his evidence that what he didn't understand is that why two sets of values, which he thought were apples to apples, and he didn't have any reason to think otherwise, particularly in light of the way his own consultant wrote that draft report, right? The report just compares them and doesn't say anything about them not being directly comparable. And so he has two values, one set of values that is higher and higher than what the MTO thought was permissible. And he was more inclined to trust the provincial authority than a UK standard, as he wasn't sure how that would apply. And so that was his explanation for why he didn't understand that. And it does appear that he was honest with his colleagues that he was still trying to figure out what the results meant. And we know, for example, in, I want to April of 2016, perhaps, but the email not long after the Lakewood Community Center makes a request for friction testing, and Mr. Moore writes to Mr. Ferguson and I believe Mr. Mader, and then it's forwarded to Mr. White, saying, you know, FYI, I have some skid testing done. I'm still trying to figure this out. And when you look at the evidence from Mr. Ferguson, Mr. White, they say that they didn't get a copy of the report, but they also say, yeah, Gary said something about it being a UK standard and not being applicable. And it also appears from their evidence, there being, again, Mr. Ferguson and Mr. White, that what they were looking for was a yes or a no, a thumbs up or thumbs down. I think both of them said that at some point. And so without Mr. Moore having that information from his consultants, I expect that he didn't have anything to share that he thought was worthwhile, particularly given that SEMA and traffic are looking at the safety of the roadway, and given that the road is in the process of being repaved. Does that answer your question?
It's an answer.
All right.
Is that your answer as well for why he gave the answers he did to the Public Works Department and the media?
So let me be clear, Mr. Commissioner. I don't have an answer on behalf of Mr. Moore. And
right.
I know what.
No, and I'm not really asking you for that. I'm asking, in a way, I'm asking for a more general question. If it strikes you as appropriate, which is, are there factors beyond Mr. Moore's assessment of the report that also explain why others in the Public Works Department didn't get the document?
Can you give that to me again, please, sir?
Well, Mr. Moore's assessment of the Tradewind report may be one thing. There may be other factors in terms of how the department interacted that explain why the report was not disseminated within engineering services, for example, and then between engineering services and traffic operations. And I'm wondering if you want to address those factors.
Sure. I have not heard any evidence to indicate that Mr. Moore deliberately withheld the documents for any reason other than based on his interpretation, perhaps. I have heard no, I cannot recall any evidence in the last two phases about why he would have withheld that. I'm sorry, I'm not answering your question, but I don't think I'm fully understanding it.
Okay.
He was candid about why he didn't find the trade report valuable repeatedly. He also, you know, being in a management position was mindful of protecting the city. And, you know, did he do that rightfully or wrongly? You know, that's of course something, sir, you're going to have to opine on. But I think because he was also in a directorial position, he was trying to think about the liability to the city, having assured himself that the report didn't actually raise any concerns.
Mm-hmm. Well, let me just give a for instance. He clearly didn't. It's not clear that the report was the friction testing was commissioned in order to address traffic safety, because he didn't seem to regard traffic safety as part of his mandate. He got it in order to have something that would be in the file for future purposes, I think, if there was some sort of lawsuit.
Exactly.
Do you agree with that? So
I'll add to that, if I may. So Mr. Cam Capistrano raises this initially at the roads level, it moves up the chain. And now you have folks from leadership positions in public works talking about this issue. And before Mr. Moore says, look, I'm going to go, I think we can get friction testing done, I'm going to go do it, a couple of things happen, right? One, Mr. White, whose group is in charge of kind of collision tracking and all of that, says, I've never heard of this issue coming up before. Mm-hmm. And then the risk folks say, yeah, I don't have any risk claims. So from that, I think we can take, not only have they identified to that date any significant collision pattern of that regard, or they haven't been receiving calls from, excuse me.
That's you.
Sorry. And calls from folks about the slippery conditions. We know that comes a bit later, but you know, at least based on what Mr. White could recall at the time, he had not heard of that. So I think that's an important part of it. It's not something that everybody had a safety concern over, but it seemed like it had kind of settled. Although Mr. White did say that he was going to go and do a thorough collision analysis. But certainly Gary was getting it as he said, for asset management purposes, in case a lawyer raises an issue in the future.
Yeah, it was more, as I read it, it was in case a lawyer raised it in the future. It was a defense to demonstrate that this highway was well built and performing just fine. So insofar as it had any significance for him in the immediate future, it was, as I understand it, in terms of assessing the quality of the pavement at that time, as part of the 6-year report that Mr. Uzarovsky was doing, which made a lot of sense. So he was not looking at it from the point of view of friction for traffic safety purposes, but rather for pavement preservation purposes, or at least assessment purposes. So I understand that. But then one would think that Mr. Andoga, who's in charge of asset management and the capital renovation of the project, would be a natural recipient of the report, but he never got it.
There's no evidence to indicate that he received it. I believe Mr. I thought Mr. Moore, and I'd want to double check this, but I'm fairly certain Mr. Moore, in his evidence stated that he would have expected that he would have given it to Rick, I think is what he might
But
have
Mr.
said.
Andoga says he never got it.
I understand that. I have to go back and look at whether it was, I don't remember, or for certain I didn't get it. But I agree with you. And I think so does Mr. Moore, that he likely would have given it to Mr. Andoga, and he can't see why he wouldn't have.
Well, I'm not sure what agreement we've just come to, but I'm not sure we're on the same page on that. But I also, the evidence seems to be that Mr. Audie never got it within engineering services.
Right. And I'm just trying to, given his role, I know that he had familiarity with the project because he worked with Mr. Moore on it, but given his role in construction, I don't know if the report would have been relevant to him.
Okay. The other thing that I wrestle with is the fact that the communication with Mr. Malone in August of 2015. I'm not suggesting there was intentional misrepresentation, but it is certainly not reflective of an accurate comprehension of the report or the context in which the report was delivered. Do you have any comments on that?
I do, sir. I think, you know, I think Mr. Moore would tell you that he, and I hope this doesn't sound like I'm making excuses for him or that he is, but that his position was very busy, that he got a call from an old colleague asking for something. He sent it. If he intended to mislead in any way, surely he would have looked down the email where it says Tradewindt. I think.
No, I'm not suggesting that there was intentional deception by any means.
It might have been, you know, a quick email where Mr. Malone said, "Is that MTO2?" Because he read it, and I can't remember exactly what the question was, but as I understood it, that Mr. Malone said, "Did MTO do both testing?" and that Mr. Moore responded, but I could be wrong about that. But I think though, whether he, you know, responded to that email with sufficient time and care, probably not. But Mr. Brian Malone's evidence on that consistently has been, we wouldn't have wanted the Tradewindt results. We wouldn't have wanted anything to do with it. We would have sent it back to the city for the city to.
Well, that's a different question.
Fair enough.
I have to address the question of why did it not see the light of day? And that's what I'm inviting you to comment on. The MTO says that around about 2010, Ms. Lane, they believe, contacted Mr. Moore after speaking to Mr. Uzarowski. I suppose I should say more specifically, believes that she would have contacted Mr. Moore. Do you have any comment on the MTO's position on that?
I don't believe the evidence is clear, even on the MTO's end on that. Certainly, Mr. Moore does not recall receiving anything along those lines. And at the very least, I expect there would have been a follow-up or something to suggest, but I don't believe the evidence is clear on either side in that regard.
Okay. In the period after 2000, after Mr. McGuire discovers the report, I know that nothing was done. I know there were serious constraints on doing anything immediate, given that they were getting into the winter period fairly quickly. I know that efforts were made to try to establish that while there was a failure of communication, let's put it that way, with respect to the report, the significance should be assessed as nil. But the city goes on and effectively says decisions were made internally that there were no additional interim measures that were required to be made. I hope I'm characterizing the situation, the city's position. I think that's what you said immediately before the break. And I'm trying to understand who exactly you think made that decision and where, if at all, is it actually evidenced?
I believe that the primary decision maker was Edward Soldo, but the evidence does, it indicates that given the time, the pressure, how new he was at the city, there was a lot of decisions were being made together. But I understand that Mr. Soldo has the expertise and runs the division that looks after roadway safety, including that of the Red Hill. And so naturally it would fall to him. Now, in light of the unique circumstances, there were a lot of other people involved. But I think that a lot of them sought assurances, but ultimately that decision, when you really listen to the evidence and it comes down to Mr. Soldo with Mr. McGuire, raising some concerns on the pavement side, saying there's not much to be able that they could do, and Mr. McKinnon, who does not have the same technical knowledge, but has the leadership side of things.
It would seem to me Mr. McGuire was struggling to understand what to make of all of this and what to do about it. And one of the indicia of that is that he never even started drafting the material for the city until the end of the first week in January, after he was prompted by Mr. McKinnon to get on with it. All the interchange with various people seem to demonstrate that he's trying to find someone who can tell him something whenever the matter comes up. I can see by your reaction that you don't profoundly disagree with that. And the problem I have with Mr. Soldo being the decision maker is that he really wasn't brought into the loop in any significant way until about certainly the early part, if not the mid part of December, when he suddenly realized that there was a serious problem here. And he felt, in fact, that perhaps because he was a newcomer or other reasons, he had effectively been kept out of the loop. So that's why I asked the question of whether Mr. Soldo can really be regarded as someone who turned his mind to this and made a decision on behalf of the city, as opposed to whether that decision was effectively made by default.
Right. Sorry, I just want to find something from Mr. Soldo that I think might be able to assist. But I think one of the earliest things that Mr. Soldo did, which was in August, was to review the 2017 annual collision, which was a PowerPoint initially, and then it turned into a report. He also looked at the memo from Mr. Ferguson, and there was that back and forth about removing the summary that Mr. Ferguson had put in about the claims. And at least the way that the Commission Counsel took him through his evidence, it was his first impression of the road is that he didn't have any safety concerns, right? I think the question that was put to him was, when you're looking at this pie chart with the high percentage of wet weather collisions, do you have concerns? He says no, because of all these other factors. And then, so he's already established that he doesn't have a safety concern. And after that, he gets a copy of the trade report. It doesn't change it. And it doesn't change it because he's been looking at the data in the last 3 years since the report. And because he knows a number of things have been done on the road since then. And again, just based on the wording of the report itself, not raising any significant concerns.
I think if I may offer the observation that you've overstated it a bit when you say he didn't have any concerns for the road, because he looked at the road, not the roadside safety assessment, but the speed assessment report or the speed study, and said based on what he could see, he didn't agree with that report. They should be reducing the speed limit. So he had a concern on that side. Did he not?
So I think that, I mean, I go back to one of the main points that I raised, which is roads can always be safer. And, you know, there's no such thing as a safe road. And certainly that's what Mr. Soldo's job was. He's coming in, he's finding ways to make it safer. But
Absolutely.
when the question is, did he have any concerns about the performance of the road? No. Were there ways he thought he could make it better? Yes. Did the Tradewind report impact that assessment? His evidence is no, and he's clear in that regard.
Okay. The last question I have is a rather different one. You've seen the MTO submissions on jurisdiction.
I have.
If you're the right person to answer this question, I invite that. If you're not,
Well, I'm
have
happy.
that.
I'm happy.
What I'd like to know is whether the city has any views with respect to the MTO's view on jurisdiction.
In terms of the
Jurisdiction.
your jurisdiction to opine on their processes and policies.
Correct. Where you draw the line.
And let me speak to my colleagues about that and get back to you. I have some thoughts, but I don't know if that's
okay. Whether they represent the consensus view.
That's right. Yeah.
Okay. Well, that's fine. Well, if we could have that addressed at the end.
Sure.
I don't mean at the end. I mean at the end today of the city's presentation. So
certainly, we'll get back to you shortly after Ms. Tlaby finishes.
Yes. So if Ms. Exactly. So if Ms. Tlaby then can be slotted in her presentation, that would be great.
Good afternoon, Mr. Commissioner. Can you hear me?
Yes, I can.
Okay, great. Thank you. I'm going to be providing the inquiry today with a summary of some of the steps that the city has taken since the start of this inquiry to date to review and revise existing policies and procedures and to implement new policies that really are meant to enhance the structural organization around information management. I'm aware of our time here, Mr. Commissioner, so I'm going to try my best to be brief. A lot of this information is, of course, available to you.
Yes, thank you.
I will first begin by highlighting some of the overall objectives of the changes that have been made. And we'll then highlight some of the key policies and procedures that we believe are relevant to the mandate of the inquiry that may be of assistance to you. And some of those policies include sharing of consultant reports with identified imminent risks to health and human safety, the council staff relationship policy, the public works quality management system, and within that, the project management manual, and the Parkway Management Committee. And so thinking through some of the sort of objectives that a lot of these changes have achieved, the improvements have mostly been made by the city to reflect best practices in municipal governance, many of which I'm sure, as you're aware, were highlighted by Ms. Baker in her report and throughout her testimony. And so in making some of these changes, the city has also been able to achieve a number of specific objectives that are important to any large organization, including the city, but are also specific and relevant to this inquiry. And so those objectives can really be categorized in three general categories. The first being implementing reliable and accessible document management systems. And what is really meant by that is creating consistent record and document management practices that enhance the sharing of information across multiple divisions and departments, because of course that is the organization of the city. And these policies effectively do this through establishing tracking and retention policies for consultant and staff reports, as well as other documents. And they're designed to ensure a certain level of consistency and transparency, which, as you know, are big parts of what this inquiry is looking at. The second sort of objective that has been achieved as a result of some of these changes is about facilitating consistent and transparent communication. And so we're talking about creating effective communication between city staff, city council, and the public. And this really is done through identifying clear processes for sharing consultant reports, which identify imminent risk to human health or safety with senior leaders and council. And again, that is of course critical, but really also sharing other types of information across the board in an accessible and consistent way. The third objective that some of these policies really achieve is ensuring that there is better coordination between groups for efficient project delivery and accountability. And what we're talking about here is really coordinating the work that is being done across the city, across various departments and divisions, and doing that through improving project management processes and really introducing tools that provide leadership with ways to ensure that there is safe and efficient operation and maintenance of various assets. It's really also specifically designed to address any fragmentation of the various structures or systems that may happen in large organizations, as these things usually do, where you have so many different structures in place. And it really allows various departments and people that are working within these departments to coordinate consistent efforts and provide oversight of roles and responsibilities across the boards. And that, of course, includes within public works. And so now just moving on to highlighting some of these key policies that I mentioned. The inquiry has certainly received a ton of evidence with respect to the improvements which are relevant to the work of the inquiry from the affidavit of Ms. Smith, the current city manager of the city of Hamilton, and through a number of city witnesses. I won't go through all of those various policies and procedures which have been updated, but I will highlight just a few key policies here that have been revised or implemented that are particularly relevant to the work of the inquiry. And some of these policies have actually been implemented on a citywide level, and some of them have been implemented within the Public Works Department specifically. And I will identify those as we go through them. So the first policy that I wanted to highlight for you, Mr. Commissioner, this afternoon is sharing of consultant reports with identified imminent risks to health or human safety. In January 2020, Council approved an amendment to the city's code of conduct to include a new schedule that has the same title as this policy, and this applies citywide. And the purpose of this policy as a whole is effectively twofold. One really is to ensure that council receives notification of imminent risks to human health or safety when they're identified by consultants working with the city. And the second is really to outline an effective process for communicating those imminent risks that are identified by consultants. And so in line with this schedule that was introduced as part of the code of conduct, the Public Works Department then developed a comprehensive departmental policy that really details the steps that staff are required to take when they receive a consultant report of this kind. And the slideshow that is before you, and I won't go through all of the steps, I'm sure you've had a chance to look at it, really talks about the details of each step in terms of how to actually escalate and communicate this information to various people in supervisory and leadership positions. And we know that in her testimony, and of course in her report, Ms. Baker had confirmed the importance of having a defined process of doing this. And in her testimony, she mentioned that this Public Works policy is essentially consistent with what she expects in terms of a process to facilitate escalating matters like this, which, where they involve imminent risk to human health or safety, or as she indicated in her report, where a consultant is providing a recommendation that might include how public safety might be improved. The next policy, Mr. Commissioner, that we wanted to highlight is with respect to the council-staff relationship. In 2021, Council approved this policy, which really provides some guidelines on the working relationship between members of council and municipal city staff. One of these particular principles that are highlighted within this policy are particularly important, I think, for us to highlight. And that is the policy that is effectively meant to ensure that council and city staff are committed to accountability and transparency. And so this policy discusses helpful context for those relying on this policy to understand specifically how the policy can be applied to some of the everyday situations that may come up for staff in relation to their communication and their working relationship with city council. And so the policy specifically states that staff need to ensure that all council members are provided with the same information on matters of general concern and/or matters that will be discussed at a meeting of council or a committee of council. And so it's really meant to emphasize the importance of recognizing the shared responsibility that exists between council members and city staff to serve the community and work together to build a certain level of confidence in the city government, but also really achieve some strategic objectives that the city has identified. And in order to do that, it's important, as Ms. Baker identified, to have best practices with respect to sharing draft staff or consultant reports with individual councilors. And this is consistent with common practice, in relation to the policies around these issues. The Baker report itself also, as you know, talks about really the importance of ensuring that all members of council and committee have equal access to information provided to them. And this policy is really designed to ensure that that is implemented consistently across the board. The next policy that I wanted to highlight quickly, Mr. Commissioners, with regards to the or I should probably say it's actually a management system rather than a policy, but it's with respect to the Public Works Quality Management System. Now, the inquiry has received a lot of evidence about the work that Public Works Department does as a whole, and it's really clear that it plays a major role in supporting the city of Hamilton to achieve its various objectives, including its vision of being the best place in Canada to raise a child and age successfully. And so as a part of the important role that the Public Works Department plays in that objective, the department has spent considerable resources developing and implementing a new comprehensive management system known as the Public Works Quality Management System that really deals with all of the various projects, factors, and assets that go into running a department like Public Works. The quality management system is really developed and operated by Public Works departmental leadership team. And it's designed to ensure that all aspects of operations, maintenance, capital renewal, all of those things are undertaken in a manner that's consistent. It meets all regulatory and corporate standards and really improves and enhances outcome. And this of course includes really putting in place initiatives that deal with program deliverables. And so in order to support the implementation of this system, as I mentioned, it does a lot of different things. The Public Works Department has come up with a number of different functional processes and policies that help achieve some of the objectives that I've highlighted. I won't, again, go through all of those things, but the one thing that I wanted to highlight for you is with respect to the project management manual. And if we can just go to the next slide here, this project management manual was put into place in 2020 across the Public Works Department. And it's meant to detail the standard processes and the tools that need to be used by project managers in Public Works to plan, deliver, and close projects. So what does this actually mean in terms of the practical implications of it? It means that this manual actually outlines the project management process in a detailed how-to guide. So we're talking about dealing with each component of a given project in a thorough way where you're providing precedents, actual guidelines, various timelines, roles and responsibilities, components that throughout the life of a project inform those involved with it, what it is that they need to do and when they need to do that. And so the manual really breaks down the life of a project into 5 different phases. The first is really initiating the project. We're talking about developing a project charter, identifying stakeholders, conducting kickoff meetings. The second being planning it. So developing a project management plan, developing a detailed scope, schedule, cost, quality, those types of things. And then it's really about executing it. And this involves directing and managing the project including all of the sort of resources that it requires, the staff, consultants, risks, and stakeholder management. And then the fourth phase is about monitoring and controlling it. And this is talking about, again, dealing with some of these scheduling, costs, and quality assurance factors. And finally, closing out the project. And this includes a closing of the project phase, which talks about financial summaries and council reports, really just highlighting and summarizing what the outcome of a given project would be. Now, I mentioned that this manual includes a project charter, and we know that Ms. Baker, in her report, really highlighted the importance of having a project charter in place for any project of any real magnitude and size, similar to some of the things that we've heard some evidence about in this inquiry. And so in her testimony, Ms. Baker really confirmed that a project charter, consistent with the one that we see in this manual, is a key communication tool in dealing with project management. It's a necessary component of ensuring that there is a clear facilitation and identification of roles and responsibilities for all of the different people that are involved. But also more than that, really the completion of the various tasks that are at hand for each of those people. The idea is to make sure that we don't end up in a situation where different divisions and different groups are working in silos without really having any visibility into what's actually happening and what each different member of different divisions are actually doing with respect to a given project. And so finally, the last thing that I will be highlighting, Mr. Commissioner, is the Parkway Management Committee. And you heard evidence as a part of this inquiry from Mr. McKinnon that this type of committee, and it was initially named the Parkway Coordination Committee, it wasn't formalized in the way that we're about to talk about today, but it really was initially some version of this initiated back in 2017. And Mr. McKinnon gave some evidence about the nature and evolution and the impetus of having this type of committee in place, really designed to ensure that any important city infrastructure, such as the Parkway, involving, again, so many different divisions that do different things with respect to its maintenance and operation, are all sort of getting together and have some level of visibility into what's going on to make sure that effectively nothing falls through the crack. And so the policy that I'm now talking about, the Parkway Management Committee, is actually effectively a formalization of that initial committee. And it really allows the various departments and those in charge of that are a part of this committee to coordinate city staff's work and provide leadership on the safe and efficient operation of the assets as we've discussed. And that again includes some of the things that we talked about in some of these other policies, right? Talking about the mandate, the scope of work, the staff that's involved, the representation, the reporting structure, and so on and so forth. But what's important and one of the key factors of this type of policy, and something that Ms. Baker talked about in her report and sort of confirmed in her testimony, is the fact that this committee is comprised of management level staff members, people that are able to make real-time decisions. And so we're talking about people from a bunch of different offices, including the general manager office, chief road official, engineering services, transportation, environmental studies. And so the idea here, again, is to make sure that if you're going to have a committee that's going to have some level of coordination and oversight, you have people from leadership positions on it that can then make effective decisions and really inform the direction of a given project. And so in her testimony, Ms. Baker confirmed that the structure and the mandate of this committee was consistent with what she would typically see or expect to see in a steering committee or similar committees of that nature for a project such as Red Hill, and to be quite honest, for any sort of large project that deals with some of the things that we've highlighted.
Mm-hmm.
And so I just concluding here with respect to my portion, again, I know that I provided you with a very quick high-level overview of some of the things that we've discussed, but I just wanted to make sure that you, again, had an ability to just have some visibility and insight into some of the steps that the city has taken. The city, obviously, as a large corporation, Mr. Commissioner, acknowledges that there is going to be a constant need for adapting, evolving, and improving. And so the policy and procedures that we're talking about, the enhancements that have been made, really reflect the city's commitment to continuous quality improvement and the integration of some of these best practices to achieve the ultimate vision and mission that the city has. And so with that, I know that you had some, if you don't have any more questions for me, if you do, I'm happy to answer them. If you don't, I'm happy to turn it over back to my colleagues because I know you had some follow-up questions.
Okay. I have one question for
Sure.
you, Mr. Levy. Going a little beyond the ones that you have described, there was reference to the chief roads officer and some uncertainty as to where that was headed. At the risk of asking you to give some evidence, is there any update from the city as to what they're planning on that score?
So I don't, I want to be careful about what I say because I obviously want to be able to confirm that with the city. From what I understand, they were reviewing that and there was a possibility of merging that role. And I think that they, just give me one moment here. I'm just going to pull this up. In Ms. Smith's affidavit, I think specifically, when we discuss that, we talk about a possibility of merging that role with one of the other roles that already
The Director of Transportation.
with the Director of Transportation, that's the one. And so I don't have any further updates on that, but I know that that's likely going to be what's being assessed and evaluated and the direction that they're going in, just because of the temporary nature of that particular role when it was first sort of conceived. With that said, the idea isn't necessarily to sort of let go of the tasks and responsibilities that have been highlighted with respect to that position, but really about how to absorb some of those things under some of these other positions and just have one person effectively deal with those issues.
And just perhaps for my own interest as much as anything, but that was at a director level. The chief road officer was at a director level.
That's correct. That is what it was at the time.
And the Director of Transportation Operations and Maintenance is obviously a director.
It is a director. That's right. So the chief, obviously, that particular role in itself was a specific role carved out, but it was at that leadership directorial sort of level. If that's helpful. I don't know if that's answering your question, but so now one director is going to perform both roles. Is that? So that's what's being looked into. So I don't want to say that decision has already been made, but the idea is exactly that, merging that role into another directorial role that already exists.
Okay. Thank you. That's the one question I had that remained.
Okay, great. Thank you so much. So with that, I'm just going to pass this over to Mr. Letterman. Just give me one moment here while we switch over.
Okay.
Mr. Commissioner, I just wanted to address that question you had asked earlier about jurisdiction.
Jurisdiction, yeah.
Yeah, that has been raised by the MTO. It's the position of the city that looking at the MTO's submission, the MTO at paragraph 190 of their written submissions says that Ontario acknowledges that the terms of reference task the commissioner with making factual findings about the friction standards in place in Ontario during the relevant periods and whether they were publicly available. And then this seems to be where MTO takes issue with your jurisdiction. It says, however, any at-large analyses of Ontario's policies, procedures, or guidelines would be beyond the scope of the inquiry, as would remedial recommendations concerning general provincial matters. And they provide example, the implementation of a province-wide FN threshold. And then goes on to talk about how evidence has not been introduced about how Ontario's policies, practices, and guidelines apply province-wide, or how and why they may be appropriate given the varied makeup of the province. So I just wanted to address that, Mr. Commissioner, in light of your question. You obviously do have jurisdiction to answer the questions that have been framed in the terms of reference. The terms of reference do specifically refer to and ask for you to consider the role of friction standards in the province and about the MTO friction testing that was performed. Although I'm mindful that obviously that an inquiry can't go beyond the jurisdiction of the municipality or the affairs of the municipality, in this case, you've heard a great deal of evidence about the uncertainty around the use of FN 30 and the lack of a friction standard in Ontario or in this country for that matter. And so in that context, it's the position of the city that you would and do indeed have jurisdiction to consider, certainly insofar as the MTO, how they have certain policies or procedures or what friction standards they may apply. In our view, that is something that is within your jurisdiction and can address in this inquiry.
Are you urging the city to make such a, the inquiry to make such a finding?
No, nothing beyond what the terms of reference provide. And so I'm simply saying that to the extent you need to consider or address Ontario policies as a way of answering the questions, then in my view, that is something that you are permitted to address and have jurisdiction to do so. But I'm not asking you to, and don't think that, and I'm not suggesting that your jurisdiction goes beyond what you need to do to consider how best to answer the specific terms of reference that have been identified in this inquiry.
Well, just as a, for instance, then, do you think I have the jurisdiction to recommend implementation of a province-wide FN threshold if I thought that was appropriate?
I do. I don't see why you would be precluded from making that recommendation if you thought that was a recommendation that naturally flows from your consideration of the existing terms of reference.
Can I draw a distinction, which may be a distinction without a difference, but and draw a distinction between recommending a threshold for municipal expressways as opposed to a threshold for province-wide application for the provincial roads as well as for municipal roads.
So, sorry, you were asking whether
is there a distinction to be drawn there between a recommendation with respect to a threshold that would apply only to municipal roads as opposed to a recommendation that would apply to municipal plus provincial roads?
To me, it would there would seem to be a degree of arbitrariness, I would think, to have a recommended friction standard for a municipal road that is comparable to a provincial road. And so I think that to my mind, would be some difficulty associated with making a recommendation that was limited to municipal roads, given the evidence that this inquiry has heard with respect to some similarity of, in particular, the Red Hill to other 400 series highways.
Okay. Anything further?
Nothing from us. Thank you, Mr. Commissioner. Those are the city's oral closing submissions.
Okay, thank you very much.
Thank you.
I think we're going to hear from Mr. Buck next. Is that correct?
Good afternoon, Mr. Commissioner. It's actually Jennifer McAleer. Can you?
Oh, I'm sorry, Ms. McAleer.
Thank you, Mr. Commissioner. I'm aware of the time. It's 4 o'clock. We had estimated that we would be 20 to 30 minutes, which is still accurate. I'm assuming, sir, that you would like me to proceed.
That would be my preference, yes.
Okay, that's fine. So as you know, my name is Jennifer McAleer, and together with my colleague Rachel Lorian, we are external legal counsel to Dufferin Construction Company. We are joined also by Chris Buck, senior legal counsel at Dufferin. I'd like to start by stating that Dufferin recognizes that public inquiries are unique proceedings that examine issues of significant public importance, and we value the opportunity to participate in this inquiry. As you know, Mr. Commissioner, the terms of reference set out 24 questions which form the subject matter and scope of the inquiry. Dufferin's interests, however, and concurrent ability to assist the work of the Commission is much more limited than that of other participants, and accordingly, we have only participated in certain aspects of the inquiry. Our involvement is really limited to the examination of the facts surrounding the construction of the Red Hill Valley Parkway in 2006 and 2007. And in particular, the aspects of the inquiry that relate to the selection of the aggregate for and the paving of the Red Hill Valley Parkway. Now, I'll just briefly address the evidence. As you're aware, sir, Dufferin produced over 2,500 records to the Commission after conducting interviews of several Dufferin past and current employees. The Commission Council called 3 witnesses who had each been employed at one point by Dufferin and who had worked on the Red Hill Valley Parkway. Those witnesses, as you know, were Peter Gamble, Dave Hayner, and Paul Yannicus. We submit that each of these witnesses testified in a forthright manner and did his best to recall facts from many years ago. And we've made further submissions in that regard in our written materials to you. Let me move on then to address Dufferin's involvement in the project. Dufferin was awarded the contract for paving of the main line in July of 2006. And the actual paving of the Red Hill Valley Parkway took place, as you know, from August 1st to 13 of 2007, so less than 2 weeks. Now, the mainline paving contract that was awarded to Dufferin was strictly for the paving of the Red Hill Valley Parkway. Dufferin did not design the parkway, and Dufferin did not establish the specifications of the SMA mix design. Those paving specifications were determined by others, and they were set out in the tender. Now, as you've heard, the mainline paving contract did not require Dufferin to use aggregate from the Ministry of Transportation's designated sources for materials. It was not a mandatory requirement of the OPSS 1003 or OPSS 1151 for the aggregates to be on the DSM list. And as such, Dufferin sought and obtained approval to use an externally sourced crushed trap rock in the super pave and SMA mixes in respect of both the coarse and fine aggregates. And it sought approval to use aggregates from the Demix Varennes quarry in Quebec. Now, it's important to note that Dr. Hassan Baj, an expert retained by Golder to opine upon the testing conducted on the Demix aggregate, explained that there would be no reason to reject the Demix aggregates simply because they were not on the DSM. And we submit, sir, there is no evidence to support a conclusion that the aggregates should have been rejected on that basis. And from reviewing the submissions of the parties, I don't see anyone suggesting that that should in fact.
That's right.
Right. Rather, the aggregate simply needed to be evaluated to ensure it met the contract specifications. And that was done in this case. The uncontested evidence of Dr. Baj was that the technical review of the demix aggregates was done properly. And as Golder has stated in its submissions, Dufferin was obliged to supply aggregate that met the contractual specifications, and it did so by delivering the testing data for the aggregate to verify that the aggregate was compliant. And as you've heard from Counsel for the City this morning, as I expect you'll hear from Counsel for Golder tomorrow, the evidence is clear that the demix aggregates were suitable and appropriate for application with the SMA mix. The evidence concerning the aggregate that was supplied by demix is clear, and I submit, sir, it's uncontested. And again, we've set it out in our written submissions, but you've heard Dr. Uzorowski, the principal pavement and materials engineer at Golder. He gave evidence that the results from the testing of the aggregate were, in his words, excellent, that the aggregate obtained results that you, again, in his words, rarely see, and that it was a good quality aggregate, and that he was impressed by how good the results were. The Commission's own expert, Dr. Geraldo Flinch, he opined that the demix aggregates used in the SMA met the requirements at the time, specifically with respect to the requirements in 2007. And then again, going back to Golder's expert, Dr. Baj, his evidence was that the polished stone value of the demix aggregates was higher than the minimum number required in Ontario and many other places, and that the demix aggregates were good for looking at skid resistance and when that may be required or needed. He also testified that the micro-Duval abrasion tests confirmed that the aggregates had good resistance to abrasion and attrition, and that the PN number, that's the petrographic number, confirmed that demix's aggregates were of high quality. So our submission to you, sir, is that the evidence is overwhelming that the aggregate that was put forth by Dufferin and approved by Golder was in fact appropriate for this project, and there's no evidence to the contrary. Now, the uncontested evidence from the Commission's expert, Dr. Flinch, is also that the mix design was appropriate. And again, there's no evidence to suggest that it wasn't. So turning from the choice of the aggregate and the mix design to the placing of the pavement, again, you've heard that Dufferin began paving on August 1st, 2007, and concluded less than 2 weeks later on August 13th. Let me address the test strip, because there was a lot of evidence when the Dufferin witnesses testified about the test strip. And while the initial test strip failed, Dr. Uzorowski testified that it's not uncommon for a test strip to fail. And he explained that the objective of the test strip was to check whether the contractor could produce the mix, place and compact it, and meet the requirements of the specifications in the contract. He also testified that Dufferin made the requisite adjustments while paving Red Hill Valley Parkway to improve compaction and to deal with the issues that were identified from the test strip. In fact, he testified that Dufferin made all of the required adjustments to meet the specifications in the mainline paving contract. And I'll simply point out as well that Dufferin was paid without reduction pursuant to the terms of the mainline paving contract. You will also recall, sir, that there were issues raised with respect to the compaction, that those issues were explored thoroughly during the evidence. My caution to you, sir, is that there is no evidence linking compaction with friction. The uncontested evidence of the Commission's expert, Dr. Flinch, was that neither low compaction nor over compaction of the aggregates would have negatively impacted the frictional qualities of the SMA pavement. So there's no connection between compaction and friction. And with respect, sorry, sir, did you?
No, go ahead.
No? Okay. So then with respect to the performance of the aggregate over time, this is one area where there is some slight difference of opinion among the experts. While Dr. Flinch opined that a drop in friction of 20% over the course of six years is a significant drop, I believe he admitted that he does not have a lot of experience with other aggregates in Canada, and as a result, he could not comment on whether the drop of 20% over the course of 6 years was average or higher or lower than average in the Canadian context. Conversely, David Hain, the expert retained by the city with expertise and experience as a consulting engineer specializing in pavement design and material engineering, had extensive experience with aggregates in Ontario. And Mr. Hain reviewed the results from the friction testing of the Red Hill Valley Parkway and concluded that the road underwent, as he put it, classic SMA trend. And he further indicated that the drop in friction of 20% on the Red Hill Valley Parkway was very typical, were his words, of what is seen in Ontario using similar aggregates. Now, in any event, Dufferin submits that there is an insufficient evidentiary basis to conclude that the demixed aggregates were somehow susceptible to undue polishing or that they did not perform as expected. Even if that were the case, which I submit the evidence does not support, there is no evidence to indicate that this would have been or should have been discoverable by Dufferin, Golder, or the city at the time the aggregate and mixed designs were approved or at the time of paving.
Mhm.
So, sir, in conclusion, to put it bluntly, it is Dufferin's position that the evidence does not support a conclusion that the choice of aggregate, the mixed design, or the placement of pavement by Dufferin resulted in increased collisions on the Red Hill Valley Parkway. That link simply isn't established in the evidence. And my understanding from my review of the written submissions of the other participants is that this is a position that's shared by all.
Mhm.
So, sir, I told you I would be brief. Those are my submissions. On behalf of myself, Ms. Lorien, and Mr. Buck, I thank you for your time and attention and allowing Dufferin to participate in these proceedings.
Okay. Thank you very much. Thank you. I do not have any questions for you. I thought your submissions were, as written, were thorough and addressed the issues that had to be addressed. Ms. Lawrence, I think that then completes the day. Would that be correct?
That is correct.
And so the first the first submission tomorrow will be by Golder.
That's correct.
On behalf of Golder. Ms. Roberts. So then we will stand adjourned until 9:30 tomorrow morning. Thank you.
Thank you.